and our guests to settle down. And it will be important for our guests to understand that this is the meeting of the Portfolio Committee on Communication. It's going to be members of Parliament talking. There is a board of SABC, and lastly, the political head of communication, Honorable Mutambi. So the guests are only allowed to sit, listen, even if there is something exciting. They must be excited, keeping quiet, or not excited, keeping quiet when members are talking. Members can joke when they talk, when they contribute. If it's a joke, you can participate, laughing, like all of us. But if it's content of what we are going to discuss, then it's a different issue. First, we'll deal with apologies before we get to introduce ourselves. Apologies. I think there is a standing apology for Honorable Ndlozi, who will be here in November. But Honorable Shibambo is here representing EFF, so EFF is represented. And maybe because that's the only apology. Maybe to start there, to say that Floyd Shibambo is a member of EFF and this committee, and standing in for Honorable Ndlozi. If you want to introduce yourself, it will be lovely to hear your voice.
Thanks, Chair. I'm also an alternate in this committee. I'm sure Tim Binkosi has captured that when that was dealt with last year. So,
okay.
So I'm relevantly in this committee to deal with all the relevant issues.
Thank you, Honorable Member. Honorable Drachen, can you introduce yourself? I'm just allowing everybody to settle down so that...
I'm Honorable Neo Druchen, or Morwen Neo Druchen, sorry, from the ANC, and voicing for me is the sign language interpreter Trudy. My second sign language interpreter is Armand Kleinschmidt. Good day, everyone.
Cope? Oh, no, IFP?
Thank you very much, Chairperson. I'm Liesel van der Merwe. I'm an IFP whip. I'm also an alternate on this committee, and I served as a full-time member of this committee between 2012 and 2014.
Yes, sir.
Thank you, Chairperson. My name is Corneille Mulder. I'm a member of Parliament and a concerned South African in this regard.
I'm Veronica van Dijk. I'm part of the committee, Communication Committee, and I'm also representing the DA.
Thank you. My name is James Self. I'm an alternate on this committee, and I'd like to record the apologies of Phumzile van Dam, who's in Washington attending a study course.
Honorable Kekana.
Thank you very much, Chair. I'm a member of Parliament and member of ANC. Thank you.
Sadi?
My name is Mosteli. I'm a member of this portfolio committee on communications from the African National Congress.
Thank you, Honorable Chairperson, and good morning. My name is Sisisi Nobuzola Dolashe, member of the ANC, member of this portfolio committee. Thank you.
Good morning, Chairperson and everyone present. I'm Sharon van Skalkbeek, portfolio committee member and member of the ANC. Thank you.
Thank you, Chairperson. My name is Mondli Kumubele. I'm here because of the ANC.
Thank you, Chair. Lerumo Kalago, member of the committee and ANC member.
Thank you, Chair. Good morning to everybody. My name is Mandisa Machoba, the member of this committee. ANC, from ANC deployment.
Hi, good morning. Good morning, everyone. I'm Ellen Prince. I'm a member of the ANC, and I am a member, chairperson of the select committee of the NCOP. Thank you.
Morning, honorable members. Stella Ndabeni Abrams, member of parliament, currently serving as Deputy Minister of Communications.
Minister.
Thank you. My name is Faith Mutambi. I'm a member of parliament and the Minister of Communications.
Can the board start?
Thank you, Chair. Mbrani Magube, Chairperson, SABC Board.
Thank you, Chair. Aaron Chizumba, board member.
Hlaudi Motsoeneng, Group Executive, SABC.
Good morning, Chairperson and members. My name is James Saguma. I'm the acting GCO.
Good morning, Chairperson and members. My name is Audrey Rapila, acting CFO.
Morning, Chairperson. My name is Krishnadu, non-executive board member.
Good morning to everybody. My name is Vusumuzi Mavuso. I'm a board member of the SABC.
Good morning, Chair and honorable members. My name is Bessie Tugwana. I'm the acting COO at SABC.
Good morning, Chairperson and honorable members. My name is Teresa Geldenhuys, the company secretary of the SABC.
Is that all, Chairperson? Are your members done? Okay. Thank you very much. We are going to start our program. I hope everybody has an agenda in front of him or her. I was told that we're still waiting for the person bringing the presentation for the chair. Has that arrived? Okay. Okay. We'll just wait for you, Chair, so that you chair of the board, so that you start your presentation. But before that, Minister is there if you want to say something before the board make a presentation as the person in charge of the department, if there is something.
Chairperson, thank you so much. You recall on your invitation, you said to me that I need to also attend. This is the meeting for the board to come and account on the implementation of the Supreme Court of Appeal judgment. So I've just come here. I think the board is best placed to deal with the matters, but if there will be questions that are directed to me, then as an executive authority, I will be able to respond to them.
No, I wanted you to say that, Minister. Members, we all have the presentation from the board. Welcome, Honorable Madisha. All of us do have the presentation, isn't it? Those who don't have, you'll get it as we go. Over to you, Chair.
Thank you, Chair. The committee, under your chairmanship, has directed a letter to me. So the issues that you wanted us to deliberate upon, we have responded in writing. But to just give a summary, all the issues that are raised, we have responded to them, and we have complied with the judgments, and I will, as time goes on, request perhaps the acting GCEO and maybe the company secretary to chip in here and there. So I'm not too sure whether, Chair, you want me to deal precisely with that presentation. You will have to direct me as to how to do it. Should we deal with the presentation and the issues that you raised?
My correspondence to the board tabulated issues that we want the board to report on.
Yes.
And that's the presentation we expect the board to present in this meeting.
That's not a problem, Chair. The only problem that I have is that my documents are now mixed. I wanted them earlier so that I can sort them out. Can I request company secretary in the meantime to be my eyes? Then I will respond to questions. Company secretary, please be my eyes.
Thank you. The first question that the PCC has requested information on was the implementation of the recommendations of the Public Protector's report when governance and ethics fail. From the presentation, you will note that the board approved the submission of a detailed implementation plan with supporting documents relating to the improvement of governance throughout the SABC. This was submitted to the Public Protector on the 22nd of August.
I thought it will be done differently. I thought the chairperson of the board needed the documents to be sorted out and so that you can make the presentation.
We can't read braille, so I thought I'm wasting my time by sorting.
Oh.
Then if you can just give me a minute or so, I'll be done. And my apologies, Chair.
No, that's fine. Yeah, I think, members, it's proper that the chair presents the presentation himself, because the company secretary will only read. Maybe the chair will read, but also expand on some of the issues. Another member Honorable Mbinda walked in, Member of Parliament. You can say yourself, Africa. You can introduce yourself.
Yes, yeah. Sorry, I'm Honorable Mbinda and I'm a member of parliament. Of course, I represent my organization.
My name is Hlaudi Motsoeneng. I represent the EFF as a member of parliament. Thank you.
Okay. Over to you, Chair.
Thank you, Chair. The first thing that I want to deal with is the Western Cape High Court page Davis J. The matter related to Democratic Alliance and SABC. The Democratic Alliance was against the appointment of Mr. Motsoeneng as Chief Operating Officer. So they believed his appointment was irrational and unlawful. I want to also make mention of the fact that, Chair, it is important to create a clear distinction between the appointment of Mr. Motsoeneng to the COO position, which the DA challenged, and his employment at the SABC. A clear distinction has to be made. We all know that Mr. Motsoeneng was an employee of the SABC at the time he was appointed as the COO. And further, that he was also an executive prior to that appointment. What Judge Davis found to be irrational, Chair, and unlawful was the appointment as COO, not his employment with the SABC. As far as the SABC is concerned, the employment of Mr. Motsoeneng to the SABC has never been challenged until he was appointed as the COO. Maybe I also need to read the paragraphs 52 and 53. In print is pages, it's page 28. It states, paragraph 52, there is a further implication which follows therefrom. As indicated earlier, the case is not about Mr. Motsoeneng, and I want us to underline that, Chair. The case has never been about Mr. Motsoeneng. Mr. Maneki, who appeared together with Ms. Raja on behalf of first to third respondent, submitted in his careful argument that there is no basis by which this court could determine the outcome of this disciplinary hearing. I want that as well to be underlined. Accordingly, if Mr. Motsoeneng is acquitted of all of the charges which are to be determined by a disciplinary tribunal, it was possible that he could be, he could then be considered for appointment as a permanent COO of the SABC. In other words, it would be a bridge too far a bridge too far to grant the applicant relief within the terms sought, namely to direct the board to recommend the appointment of suitably qualified COO within 60 days of the order of this court, and hence ignore the outcome of the disciplinary process. That was paragraph 52. And 53 says, much has been made by respondents of Mr. Motsoeneng's achievements at the SABC and unique ability to be the COO of the SABC. If it is properly shown that none of the allegations made against him are sustainable, it would be unfair and hence premature at this stage to preclude him from such consideration. In summary, it is preferable to allow the relevant disciplinary proceedings to run its course and to reflect this finding in the order. Hence, I agree with Mr. Maneki so that this is the prudent course of action. Accordingly, I propose to tailor the order which is to be granted accordingly. Mr. Motsoeneng went through a transparent and independent disciplinary hearing, and he was cleared of all the charges, Chair. Based on the ruling above from Davis in the Western Cape High Court, case number 12497 /2014, Mr. Motsoeneng ought not to be excluded from applying for the position of the COO once it is advertised. In fact, the ruling did not, Chair and honorable members, exclude him from being appointed as the acting COO. What we also have to bear in mind, Chair and honorable members, is that in an earlier judgment, Judge Skiepers made a comment that he makes no findings on whether or not Mr. Motsoeneng was guilty of improper conduct, maladministration, or abuse of power. But instead, he ordered that Mr. Motsoeneng be subjected to a disciplinary hearing that will be chaired by an independent chairperson. Chair, it is common knowledge that the SABC went beyond that by ensuring that both chairperson and the initiator were independent people. We even conducted this hearing live so that there wouldn't be any aspersions cast on SABC. During the disciplinary hearing, Mr. Motsoeneng was not found guilty chairperson. That is the first matter that I wanted to address. Now let me address the second matter, which is about the Supreme Court of Appeal. The Supreme Court of Appeal, Chair, subsequently found no basis to interfere and dismissed the appeal because there were no prospects of success. The prospects of success was or is relating to the fact that the appointment was considered to be irrational and unlawful and has nothing to do with Mr. Motsoeneng being an employee of the SABC. The third matter, that of Mr. Aguma, that he is laboring under an incorrect understanding that he has the necessary authority to appoint Mr. Motsoeneng as a group executive without reference to the board and without reference to the human resource and employment policy and procedures of the organization. Chair, here without any consideration of the damning allegation that Mr. Motsoeneng is the recipient of a substantial amount of money from the SABC without lawful reason, which allegation the public protector saw fit to investigate, and without any appreciation of the law and the principles of good governance, that the appointment of Mr. Motsoeneng, albeit that he, Mr. Aguma, does not require board approval. This approval will have the intended or unintended consequences of subverting the rule of law. Clause 13.8.1 of the Memorandum of Incorporation, MOI, it stipulates the following, Chair. It stipulates that the powers to appoint and to discipline staff and members of the SAB management team are delegated to the GCEO, CFO, and COO, and can only be revoked by the minister. This requirement is included under clause 4 of the Delegation of Authority Framework, DEF, regarding the appointment of the members of Group EXCO and top management on levels 110 and 115, and stipulates the authority granted by the MOI with the following business context. Appointment of all employees is subject to human resources appointment processes and budget approval for the position. The powers to appoint and to discipline staff and members of the SABC management team are delegated to the GCEO, CFO, and COO, and can only be revoked by the minister, MOI, that is 13.8.1. As a board member, I want to indicate that board members have approved the DEF. So what the GCEO, COO, and CFO did was within their powers to do so. I'm just scrolling down to go to the next point, Chair. What is the other thing? It took me a sec. Which other point? What was that point again? Which one? Chair, I think in a nutshell, those are the issues that you wanted us to clarify. Thank you, Chair.
Thank you very much, members. I'll come to you. Before we go to engagement, questions and clarities, and then engage. I was given members of the board as follows. You, Chair, Prof. Maguve, Dr. Chitumba, Mr. Mavuso, Mr. Naidu, from the executive, Mr. Aguma, Besi Tugwana, Audrey Rapela. I was given those. There are two people that are missing in the list, I'm told. I'm told it's Mhlakaza and Kumalo. Can we, having read all that, can we get explanation as to where these two are? Remember, we wanted the full complement of the board to be present in the meeting.
I'm sorry, Chair. I should have indicated that they have apologized due to prior engagements. The invite was circulated to all of us, but they unfortunately can't be here due to prior engagements.
Okay. That's the apology, members. In all what was presented here, we really need to, as we explain or respond to questions, we need to be very clear as to decisions of the board in relation to the presentation, the issues that are presented here. The board members are so many, and in decision making, here are the people, or decisions were taken by so many people. I think those are some of the issues, members, that the board, as they respond, must explain to the meeting. The board courageous to take decisions. The quorum must be present in taking decisions. I think we need to emphasize that so that we are clear. What are we talking about in relation to the presentation? Members, can I have you, Honorable Kalako, Honorable Kongubele, Honorable Tsedi, Honorable Self, Honorable van der Melve, Honorable Shibambo, Honorable Madisha. In that order, Honorable van Schalkwyk. And I know Honorable van Dijk will follow Honorable van Schalkwyk. Thank you. In that order, Honorable Kalako.
Thank you, Chair. Thank you for the presentation. Chair, I see the and I've read the presentation. But I think the issue we are dealing with is not only an issue related only to the answers they have given us. Because the public protector's findings and remedial actions, they mentioned many things there. It was not an issue of Mr. Motsoeneng only. It was about many of the issues within the board, which the board was asked in the SABC to actually correct them. In this presentation, the board, I haven't heard the board getting to that, which leads me to a question whether the board is aware of the public protector findings and remedial actions, and whether did it take responsibility to make sure that it implemented those findings. It's a pity, Chair, because this issue has been in the courts for a long time. Here in the committee, we didn't have time really to look at it, precisely because it was in courts. So, to me, I think the body will have to clarify us on that, on all the issues. For instance, there was a call for a public apology to affected people on decisions taken by the board. And also there have been mention of to correct any fruitless and wasteful expenditure. These are issues which the board must actually clarify from us and actually tell us whether they have really implemented. Because now everybody knows the public protector's recommendations are binding now. It's not an issue of, oh, okay, public protector. Everybody knows now that they are binding. And secondly, Chair, I will want the board to actually tell us how many meetings have they convened as a board this year, and what resolutions have they taken? And also in considering this matter, did the board correct in all its meetings as it was taking all these positions and making changes in the board and SABC? So that, Chair, we are able to see whether problems which are emanating there in the SABC have been addressed thoroughly by the board, and they have implemented all what was proposed by the public protector. So to me, that is, and if you, Chair, you'll remember, the board is 12 non-executive and 3 executive. Now you have a situation where you have a group CEO, acting group CEO, you find in that position CFO acting. Then you have now this other position. So it means already in the board, where the board will clarify that, already in the board there's a shortage, despite other, we know that there are still vacancies which are not filled in the board, have not been filled yet. So that is why I'm asking this question, whether the decisions the board was taking, did it correct? Were those decisions legally binding? I think they will have to actually give us an explanation on that. The other one is, Chair, on the court cases which have been raging within the SABC board, within the SABC. What was the role of the board in that? Why did the board look into who actually, when it comes to costs, who paid the costs of all these court cases? Is it the SABC or individuals concerned? So I'll want a clarity on that, Chair. Thank you, Chair.
Thanks. Kungubela?
Thanks, Honorable Chairperson. I tried to listen to the chair of the board and the assertions he's making with regard to what the court was concerned with and what the court was not concerned with. He seems to be having his own understanding. What was the gist behind what determined the attitude of the court? But I want to leave that the chair will remember, and together with the board, that it is clearly known that from King Tree, for instance, the board is supposed to be the focal point of corporate governance. And if you go to company law in general, it's a tried principle that company must be seen to be a responsible corporate citizen, seen by the public. There is no longer an argument now that the public protector's remedial action have got legal effect and they are binding. That's a very important point I want to throw to the board. Remedial action, they are binding. They are not there for the reviewal by the board. It appears that your DC seemed to sit to review the remedial actions of the public protector. Public protector had clear findings on the COO that time with regard to how he increases salary 3 times in a year, how certain officials were illegally promoted, how certain officials were illegally fired, lost in the CCMA, and all those issues. Those are clear findings of the public protector. And the Constitutional Court says those remedial actions of the public protector are binding. Now, my understanding, therefore, is that this is my own little understanding, that if they are binding, it means yours was to implement those remedial actions. Because if you had a different view, you had to ask the court to review them. And you did not do that. Remember, the court was dealing with issue of appointment, that was all. Now, if my assertion is correct, it doesn't make sense, therefore, if you are to be seen as a company with being responsible corporate citizen on issues of governance, you appoint an official who has not been acquitted on the list of issues the public protector has articulated, which you have not asked any court to review, but you decided through your own processes to set them aside. If that is the situation, the question that can be posed to you, did Mr. Motsoeneng qualify to be appointed in any position in the SABC against this background? And I think this question, it begs the answer from the board. And remember, there are also issues here where the board that precedes you would have appointed would have recommended the appointment of a CFO. And it's on record, it's a public knowledge that different exercises were undergone, which again are viewed by the public prosecutor as breach of the corporate governance principles and its imperatives. I don't want to spend a long time. I think this to me is a fundamental question that the board must respond to. That the remedial actions of the public protector, yours is to implement them. If you can't implement them, you've got a different view, court must review. We don't come across at what point did you do that. It will also be assisting, Chair, if we can be given a record of the script of the disciplinary processes.
Yeah, can you take that as one request that the committee is making from our side as the committee, from the board, the record? Because these things are important for us to be clear as to what has been happening. Honorable Sedi, I think.
Thanks very much, Chairperson, for the opportunity. The process leading to the appointment of Mr. Motsoeneng to the current position, we will appreciate if you can just be clarified. If there is a policy as well that relates to the process that led to the current position that we're talking about, we'll also appreciate if it can just be clarified, Chairperson. In your presentation, you talked about the reorganization of the structure of the SABC. And I'm interested in knowing whether the reorganization was done at the stage you needed to appoint him at the current position, or whether it was done before. And the last one, it's we're in a situation where we have 3 executives in acting positions. Acting GCE, acting COO, and the CFO. I'm interested in knowing from the board's perspective the effects of these acting positions to the affairs of the public broadcaster. So we'll appreciate if the board can as well clarify the implications that these acting positions have to the running of the affairs of the SABC. And lastly, it is linked to the issue that was raised earlier on. It's with regard to the scope and the terms of reference of the disciplinary hearing that you spoke about, Chairperson, earlier on, as to whether at any given stage the board did deliberate on the scope or the terms of reference immediately after that pronouncement was made, or a decision was taken to clear Mr. Motsoeneng, as followed by the DC process. Thanks.
Just to finalize that question, the acting GCO, the acting CFO, and all of that, you say, what is the impact in the organization?
Yeah, that's what I'm interested in.
But taking it forward, what has the board done so far in terms of stop the acting, acting in SABC, but people full-time. What has the board done in relation to fill the posts where they are acting people? I'm just adding on your question.
Exactly. I think that's the point. Yes. Exactly that one. So if there is a plan of action that the board has to deal with that particular challenge,
that's right.
Because surely it has some implications.
Honorable Self, thanks.
Where's this button? Thank you very much indeed, Chairperson. In the first instance, I'd like to give the committee 4 copies of court cases that we have fought over this issue for the information of members, because I think they demonstrate a sorry history of ducking and diving and of obfuscation and of avoidance. Starting off with the avoidance of the very pertinent remedial action that was ordered by the Public Protector, and then avoiding the consequential actions or judgments of not only the Cape High Court on 2 occasions, but also the Supreme Court of Appeal. And I find that it is almost surreal that in the face of a Chapter 9 institution finding and judgments by 3 different courts, that we can find ourselves in this meeting still discussing whether or not Mr. Motsoeneng should or shouldn't be a member of the staff of the SABC. Now, this has gone a long way, and I'd hope that this is the beginning of the end of it, because the presentation that we saw here is at best disingenuous, because it doesn't address the real problems. It's sort of technical response which has characterized everything that the SABC has given in its court defense. But let's just start with the argument that that Mr. Motsoeneng was cleared by a disciplinary hearing. That disciplinary hearing took place in mid-December last year. It was a complete farce. Critical people were not called as witnesses. No evidence was led at all in respect of one of the charges. It's wrongly sought to second-guess the findings and remedial action of the Public Protector, and for that reason, the Democratic Alliance has taken that disciplinary proceedings on review in the courts, and we are now awaiting a judgment on that matter. But it goes beyond that, in my view, because the Cape High Court and the SCA found that it was irrational and unlawful to appoint Mr. Motsoeneng as the COO, not only because of the Public Protector's remedial action, but also because of the cumulative damning findings they made about Mr. Motsoeneng in the course of that report. And those findings and remedial action are binding unless they are set aside on review. Now, my understanding is the SABC has, in fact, launched a review application, or seeks or purports to want to do so, which brings me to the point that was already being raised here around the legal fees. I mean, we are now litigating in millions of rands. According to the latest SABC annual report, the legal fees went up from 171 million to 257 million rands. And I would argue that if people want to litigate to look after their positions, they must litigate in their personal capacities and pay for the court cases themselves. They cannot make the corporation pay for it. So that's the one aspect. Then let's come on to the appointment of the Chief Executive Corporate Affairs. And it is true on one narrow definition that the appointment was lawful because it was made by the right people or the right person. But there are 2 other aspects that I think are relevant in this respect. And Mr. Justice Davis found that Mr. Motsoeneng could not be precluded from consideration in the staff position because it was possible that the public protector's findings would be proved false. Now, there's only one way in which the public protector's findings can be found to be false, and that is if you take the matter on review. That action has not yet happened, and it can only happen if her findings are reviewed and set aside by a court. It is plainly contrary, in our view, to the findings of 3 courts to appoint Mr. Motsoeneng as the Chief Executive of Corporate Affairs while the Public Protector's findings still stand. And I think we need some very honest answers out of the board, because it is true, as I said, that people can make that decision and it's not a board decision. But the board has a fiduciary duty to oversee the activities of the chief executives. And if it fails to exercise that power, then it becomes complicit in unlawful and bad decisions that are taken by the management of the SABC. Quite apart from the fact that it was against the law in our view. Thank you, Chair.
Thank you, Honorable van der Merwe.
Thank you very much, Chairperson. I would like to firstly say, Chairperson, that I think the presentation that we've been given today is an absolute, it's just not, it cannot suffice. I think the information that we've been presented with is mere smoke and mirror type of arguments and explanations that this board is advancing. And I think first and foremost, we must acknowledge today that we've got a politically compromised board that is sitting in front of us, that are have not only ignored binding findings by the public protector, but have willfully and purposefully ignored court findings. You are also not adhering to the Broadcasting Act. You are not complying with your fiduciary duties. That's why we've seen another 400 million rand loss. And so I think the chairperson is quite right when he says this is not only about Mr. Motsoeneng. It's not only about Mr. Motsoeneng. It's about a board that has failed this organization. And I listened to what the chairperson said in terms of who decided to give Mr. Motsoeneng his job back, or his old job back. And that is all fine and well because you do have those powers, CEO. But the fact of the matter is the public protector's findings, as my colleagues have said, are binding. And no DC or a kangaroo DC court that was instituted could actually overturn those findings. And Chairperson, I also want to have some clarity today in terms of the increase in salary that Mr. Motsoeneng has again received. Also, there are reports of another bonus that Mr. Motsoeneng has received of 11 point something million, and I think we need to get some clarity on that issue. The Honourable Self has just spoken about frivolous court cases or court cases, and I think we need also today to hear about whether this board will be collectively held responsible for the expenditure for these frivolous court cases. I also, watching the press conference where Prof. Maguve had actually announced to South Africans that he is reappointing Mr. Motsoeneng into his old position. I also want to say that I take great offense to both the CEO and the professor, the chairperson of the board, again saying that political parties should not interfere in the affairs of the public broadcaster. In my mind, you are then saying to every South African that you are not a stakeholder in the public broadcaster. You are saying, hands off, you do as you please. We as ordinary South Africans that are expected to pay TV licenses have got we are not allowed to make any inputs or give any insights into the public broadcast. And I think it shows very poor leadership on behalf of the board, that you again, every time when you're at a press conference, every time when you address critical issues which South Africans are concerned about, you want to blame political parties or opposition parties. And I really think it's time for this board to acknowledge that you've failed in your duties, that you are no longer fit and proper to be a board that leads the public broadcaster. And I think eventually we will have to get to the point where we talk about the elephant in the room, and I'm not talking about Mr. Motsoeneng, because he's not a board member, but about how we got to the point of appointing this board, because I served on this portfolio committee between 2012 and 2014, and it was a very difficult process, because I said at the start, this is a politically compromised board chairperson, because while we were interviewing each and every member that serves on this board, political interference were part and parcel of how we got to appoint this board. And once you appoint cadres to a board, then you'll have a situation which we've got here. So if we do get to that point where we go for an inquiry or we talk about whether this board is still fit for purpose, we must also talk about the failed process that led us to appointing this board chairperson. That being said, I think we really need answers today from this board. You have failed us because this is not just about Mr. Motsoeneng, it's about the rule of law. It's about doing what is right and what is wrong. And I feel sorry for Mr. Naidu here because he's actually been brave enough to speak out against the actions of the board. And one also thinks about the bravery of the late Hope Zinde, for example. But let us leave here today with the common understanding, chairperson, that we need to rescue the public broadcaster from a board that is no longer fit to lead it, chairperson.
Honorable Shivambo.
Thank you very much. Thanks, Chair. One of the most important judgments in South Africa since constitutional democracy, which includes everyone, was the judgment delivered on the 31st of March by the Chief Justice on the matter between the economic freedom fighters and the Speaker of the National Assembly, which put to rest the powers of the public protector, whether they are binding or not, whether the remedial actions are recommendations or not. And part of that judgment says that the investigative powers of the public protector are not supposed to bow down to anybody, not even to the door of the highest chamber of raw state power. That same judgment also says that if compliance with remedial action were optional, the very few culprits, if any at all, will allow it to have any effect. It also says that the public protector would arguably have no dignity and be ineffective if directives could be ignored willy-nilly. Those are some of the things that are contained in the judgment affirming the powers of the public protector. And the interesting thing that relates to this question is that that court also expressed itself on what happens if those who are supposed to comply with the public protector remedial actions engage in a parallel process. With regards to the case that was taken to the Concord, the Chief Justice said that the end results of the two streams of investigative processes were mutually destructive. And it says then that the President should have decided whether to comply with the public protector's remedial action or not. If not, then much more than his mere contentment with the correctness of his own report was called for. A branch of government vested with the authority to resolve disputes by the application of law should have been approached, and that is the judiciary. Only after a court of law had set aside the findings and remedial action taken by the public protector would it have been open to the President to disregard the public protector's report. Now, we're speaking about a president here of a republic, the head of state, who is instructed by the constitutional court to abide by the remedial action of the public protector. Now, what are the findings of the public protector on the SABC? Maybe we must beg your indulgence, and then I'll take you through some of the findings of the public protector on Mr. Motsoeneng, whom I've never got to meet with him anyway. I see him on television saying that he gets out of all troubles. He's MacGyver of our days, who even when situations are very difficult, want to see how it's going to pan out this time. Part of the findings of the public protector is that the allegation that Mr. Motsoeneng committed fraud by stating in his application form that he had completed matric from Mitsimanso High School is substantiated, meaning that it's there. By his own admission, Mr. Motsoeneng stated in his application form that he had passed matric standard 10 filled in made up symbols in the same application form and promised to supply a matric certificate to confirm his qualifications when he knew he had not completed matric and did not have the promised certificate. And this he admitted it in the public protector interview process. There is verbatim reflection of him saying that a Miss Sonepol told him to fill in fake information about his matric status. And then the public protector further finds that the allegation that Mr. Motsoeneng was appointed to several posts at the SABC despite having no qualifications as required for such post, including a matric certificate, is substantiated, and this constitutes improper conduct and maladministration. So while sitting with an acting executive of something, I don't know what it is because he becomes everything he wants to be, who has been appointed through an improper conduct and through maladministration. And then we must sit here, still have to listen to a board that wants to protect such a person, despite the fact that these findings have not been subjected to a judicial review. And even if you disagree as board members, your right to differ is insignificant. It dwindles into insignificance altogether. Once there's been a ruling that these are the situations, you have to abide by that. You can't engage in a parallel process that deliberately reaches a different conclusion. Parliament attempted that. The Ministry of Police attempted to do that. They went to Nkandla to show bioscope and trying to justify a swimming pool as a fire pool and all sorts of things. And it all fell flat when the Court said that all those activities that we're engaging in are illegal. You have to abide by the rule of law. So the board can't even mention a disciplinary process, a fast disciplinary process that ignored the core findings which they have not judicially reviewed. So unless these findings are judicially reviewed, they hold legal status that must guide what the board does and everything else that was supposed to do. So in fact, we are sitting with an illegal appointee in the SABC, not even as a COO, not even as an employee, even as a sweeper. If it requires a matric certificate, the public protector says that he's not supposed to be appointed there because those are the findings. We can challenge that in a court of law, not on a process that we have self-appointed ourselves. Let us deal with the way forward. What should happen? Number one is that the board must be instructed to reverse the appointment of Mr. Motsoeneng because such appointment constituted maladministration and improper conduct. That is what should actively happen. There is and number two, we should as Parliament institute an inquiry into the fitness of the board to continue as the board of the SABC. One, we must investigate their suitability to carry full fiduciary responsibilities as is required by the board charter of the SABC. So fiduciary responsibility would mean that it's a position of trust that we as the public, of the public broadcaster, the public, it's all of us here. We represent the public, we're public representatives. Can we trust the board to carry forward proper management of an institution that is supposed to educate the nation, inform it on critical information in terms of what should happen. But also we should have an inquiry on the board's inability to stabilize the management at the SABC because everyone else is acting there. We know that television goes hand in glove with acting, but not at management level. Acting happens on the screens and generations and all those things there. But at management level, we need stability. It can't be for a very long time. There's acting CFO, acting CEO, acting COO, acting executive corporate affairs, acting special projects, acting everything. All those actors must fall. There must be stable leadership. And it's not even an issue of negotiation. It's an instruction that you have to be given. We are not here to represent our jackets, and we are here to represent the people of South Africa. And the people of South Africa expect that there must be stability in all public institutions, and that is what should happen in the SABC. But also, I get a sense that there are board members who are appointed by Parliament and got removed by the board itself without consulting Parliament and the appointing authority. That is illegal. Where do you get the power to remove board members? Who gives you the power? Because we never appointed you to go. Even your board charter, there's no piece of legislation that empowers any of you to remove board members because you never appointed them. The people who appointed that, it's us as Parliament who recommended to a president to appoint. So that is there's a process that is outlined in the board charter on how members of the board are removed. So in concrete terms, I don't think that we must tiptoe around an inefficient, clumsy board of the SABC that comes with a lousy presentation here, doesn't say exactly what they've done with each and every remedial action of the public protector, and says that everything else is fine. We say there, what are the implications of the SCA judgment? What are the implications of the High Court judgments? And then they say there's no implication. That is pure arrogance that is being displayed in front of us here. We must take action, and we have to take action now because we cannot continue to be run like that. The time of games has come to an end. Thank you very much.
I'll come to you, Honorable Van Schalkwyk, and then to Dr. Mulder, Honorable Tolashe, Honorable Van Dijk. Anyone else? Anyone, Honorable Machoba? Can I say this, members? Let us for now engage on the report that we were given. There will be time when we must look at all these issues that members are saying in terms of the fitness of the board. There will be that time. For now, let us engage, and the processes will follow where the committee will have to engage and with itself and take a resolution on what must be done. I think let's do that. Let's move towards engaging the report, punch holes, criticize, and do all of that. But at the end, we'll have to come to a session where we say, this is what we have got from the board, and therefore what do we do as the committee? Can you move towards that direction at some stage? Honorable Van Schalkwyk.
Thank you, Chairperson. My question is directed to the Chairperson of the board who made the presentation. He's mentioning that on the 25th of February 2016, the board approved the reorganized structure, which includes the renaming of the GE stakeholder position to the GE corporate affairs position. So I would like to know, when you changed that position, how did that impact on the benefits, salary, and the status of the new position versus the old position? And then afterwards, after the judgment has been implemented by the SABC or tried to be implemented, you've mentioned that the only position that was relevant to Mr. Motsoeneng was the position of GE Corporate Affairs, as he didn't have the competency to occupy the position of GE HR that was vacant. So I would like to know the position that is currently employed in, that he was moved to, that was upgraded in February. Was that position vacant when he was appointed or not? And if not, how did it came about that he occupies that position? And also the processes that has been followed to occupy or let him occupy this that position? Because we know that there is employment processes, internal employment processes that needs to be followed in order to let someone occupy a specific position. So can you just clarify that? Thank you.
Yes, thank you. Thank you, Chairperson. Thank you for the opportunity. The Honourable Van der Merwe referred to a press conference that she watched recently by the SABC. Now, I watched another one recently, and I saw the acting COO talking to the media, and he said, well, you were all expecting R1 billion deficit. It's only 400 million. Now, that was, to me, a rather strong red light of what's technically happening around the SABC, unfortunately. And I'm happy this morning, Chairperson, that it's not only the board that is present. We've also got the top management, the executive management of the SABC itself present, because we should not only focus on the board, because the board is not there on a day-to-day basis. The SABC is being run by the management, the executive management of the corporation. The board comes from time to time, and yes, of course, they've got a fiduciary duty, but the emphasis should also be on top management. Now, there was a time not very long ago that the SABC was the gold standard of broadcasting in South Africa. And I'm afraid we all know what the current situation basically is. Now, I've got sympathy with the board and the management with regard to the implementation of the actions taken by the Public Protector. Because the Public Protector's report was some time ago, and then you had a disciplinary hearing, and you referred to that just now, in December of last year. At the time when those things happened, we did not already have the court case of the Constitutional Court in March of this year, which now clarified once and for all what should happen in terms of remedial action expressly put into place by the Public Protector. And unfortunately, that question marks being put on the actions of the Public Protector started here in Parliament. So you obviously took the key from there. But now we know what should happen in terms of the remedial action taken by the Public Protector, also with regard to the SABC. Now, in the report that we've received today, the feedback that we've received creates the impression, or it tries to state that everything is fine. There's no problem, everything has been handled, there was a disciplinary committee, etc., etc. But that cannot be relevant anymore, because the SABC should now know what the Constitutional Court found in its very precise judgment with regard to the Public Protector. So you can ignore what the disciplinary committee said, and you should implement the findings and the remedial action taken by the Public Protector. Two things that bother me, Chairperson, and you're correct, we should deal with those things at some stage. The one has been referred to, the salary increases received by Mr. Motsoeneng 2013, 2014, and after that. And we all know the figures, 1.4 million, and then very shortly after that to 1.7, that's a 21% increase. And then it jumped to 2.4 million, that's another 41% increase 4 months later. But maybe at the bottom of everything is this very disturbing figure that I see, that in the recent past, more than 53% of the staff of the SABC has resigned. Why would that be? Maybe we should start there. Thank you.
Thank you. Honourable Van Dijk.
Chair, Section 11.3 of the Public Reporters report outlined that the remedial action that should be taken by the SAB board, and it says that all monies which were irregularly spent through unlawful and improper action should be recovered from the appropriate persons. And my question would be if any of the fruitful and wasteful expenditure that has been incurred as a result of the irregular salary increments to Mr. Motsoeneng, Ms. Motsoeneng, Ms. Kumala, if that has been recovered from the appropriate persons, and if not, why not? And I would also like to know the board, if it also, according to this actions that they should have been taken, the appropriate disciplinary actions, if they follow that with regards to, it points out in 2.AA that I want to know what disciplinary actions has been taken towards Mr. Motsoeneng for his dishonesty relating to the misinterpretations of his qualifications, the abuse of power and the improper conduct of the appointments and salary increments of Ms. Hlaudi Motsoeneng, and for his role in the purging of senior staff members, resulting in numerous labour disputes and settlements awards against the SABC. Thank you.
Thanks, Honorable Matisha. Sorry, I jumped you.
Andiyabulela Mhlekazi. It's okay. My chairperson, permit me to once again indicate that the SABC belongs to the people of our country. And we cannot allow any one individual to destroy that which belongs to more than 50 million people of South Africa. We can't. Now, let me first start with the board, because it's a group of two persons, a group of one person who is the culprit here, permit me to say that, and a group of many persons, which is the board, okay? May I check with the honorable respect, my chairperson, why has the board employed and again saved a fraudster? Why have they done that? It's a fraudster because here we're dealing with a person who misrepresents his qualifications. Are we therefore sure, as the representatives of South Africa, that he will be, or will he continue to be less fraudulent as he continues to do that kind of thing? I wish to say that, in my own opinion, the antithesis is the case. We're dealing here, I want to emphasize to the board that we are dealing with a fraudster. Because in the very same way, persons who have gone out, looked for jobs, shown those kind of certificates, etc., they have been indicated, it has been said that they're fraudsters. I'm therefore moving from that president. Now, the increment of monies, of salaries, despite the fact that he does not have the qualifications, okay, that is a major, major problem. My chairperson, Mhlekazi, move out. The children are not going to school, the students are not going to school. We have all these kind of problems. And here is a person who, despite the fact that almost 4,000 people in SABC are not getting any increments. Here is a person who will take more than 3 million, have that increase to more than 4 whatever million, who will take that within a very short period of time up. A person who will get more than 11 million rand, they say that that is a bonus. And they further go on and say that is not enough. You'll get 33 million again. Is the board doing okay for us? This is the question that I'm putting through you, Mhlekazi, my chairperson. Is that proper? Because our country is collapsing. Our country, economically, our children are faced with this kind of a problem. And we have a person who takes that which belongs to the people and does whatever he wants. And when the people say, but here you are wrong, he climbs on the stages and starts, saying there is nothing that you can do to me, etc. And when we call the board here to say, can we talk to you, he sits with the board as if he's a member of the board. Kindly, please, and actually advises them that you must say this, etc. So I'm putting that to you, my chairperson, as part of the questions that I am raising. I further am saying that, is it proper that he goes on to ill-treat workers, he goes on to fire workers, just because of they are requesting for, nothing, and thereafter he says, come back, it's okay, and so on. I'm putting that to the board via you, because I'm talking here about a person who I wish to re-emphasize is a fraudster. And I'm coming back now to the board, the second person directly. I say to the board that you are unfit. Can you say to me that you are fit, and the members of parliament here, that you are fit? Because if you go on and ignore the law, that is a problem. I mean, even the president of our country, whom I respect very much, has reason to say, but no, please, board, let's look into this thing. But then the board has ignored that. Even when the majority party, I mean, that is an open secret, has reason to say there is a problem here, can we do something? That has been ignored. Can we therefore say, through you, chairperson, that the board is fit to do that? The board that says to the public protector, you can't tell us anything. That tells the Western Cape High Court, you can't tell us anything. The Supreme Court of Appeal, you can't tell us anything. And the board that, instead of addressing the problems, it shifts this, permit me once again to say, fraudster, from one high position to another very high position. What do we do as the 50 million people of this country? And permit me to end by asking, you as the board have indicated that you have come up with a DC, disciplinary committee. Who appointed that? What were the processes? What did it have to follow? Those particular processes, who drew them? I say this because, in my own opinion, you are part and parcel of this whole thing. And therefore, I believe that there are very serious problems. And like and all the other MPs here, honorable MPs have said, I think we have a very, very serious problem. And you as members of the board, don't you just want to go to meetings every time because of the amounts of money that you get for meetings? I mean, from one meeting to the other. I know that in the past it would be 5,000 per meeting, 5,000 per meeting. It now has gone up. Is it not? Is that not part and parcel of this whole thing? Are you fit?
Yeah.
Thank you, Mklegas.
Thank you. I will give Honorable Machoba, Honorable Tolashe, Honorable Mbinda. This is the first round. I want the board to respond. But before you, Honorable Machoba, let's tone down on the language. The fraudster, for someone who cannot respond, it's not proper.
But
no,
Chairperson,
you will argue at
but
some
Chairperson,
stage.
the public protector report says that
Imagine-
Hlaudi has fraudulently represented his matric certificate.
No,
And if you fraudulently represent
understand
something,
that.
you become a fraudster.
We understand that.
So it's English, it's basic language that if you represent something wrongly
We
through
understand
fraudulent
that.
means you become a fraudster.
We
So there's
understand
nothing unparliamentary and wrong with what Honorable
No, I'm
Madisha
not
is
saying,
saying.
Honorable Shibambo, please. I'm not saying it's unparliamentary. But when you call a person a fraudster, I understand English. Person who's fraudulent. But this is a discussion that we must handle carefully. I'm raising it because this is what I said in the last meeting when he was going on to say members are not honorable. At the end, I said it's not correct. You can't have members of parliament that are told by the official are not honorable. This is what I said. And I think, and again, when I was talking to one of these radios, because they continued to play what he was saying and never played what was the chairperson was saying. Let us be very careful. I understand, but let us be careful so that at the end we can do what we want to do. I know he cannot stand up and defend himself, but the board will have to respond. I understand you, Honorable Shibambo, very well on that one. I wanted to raise that, member, so that we tone down a bit on our language, because, you know, people are human beings. Bantu ngabantu. So let's not careful, but let's think of other people. I think we've heard Honorable Madisha. It's fine, but I'm saying tone down in that kind of language. Honorable Motsoeneng.
Data.
Yeah.
With your permission,
No,
for
I'll
the
come back
sake
to you.
of the 50 million people, we shall tone down
Okay.
as long as they are respected.
Okay.
50 million people,
Thank you very much.
even if you take anything from them.
Thank you, Chair. Thank you to the board members to give us this burning report. My first question, Chair, I have only 2 questions. I just need the clarity around them. Before Mr. Motsoeneng was irregularly appointed as an acting COO, what was his position before? And what was his package? Number 2, who occupied the position before and why was she removed? What processes was followed to remove her or him? In the issue of appointment of Mr. Motsoeneng in the position after the COO, Motsoeneng, I'm very sorry to announce your name badly. When was the vacancy of the general employee created? Who created it and what were the recruitment procedures followed? When was the vacancy of group executive, corporate service and provinces created? Who created it and what were the recruitment procedures followed? I just need those 3 clarity. Chair, thank you.
Thank you very much, Honorable Motsoeneng. Honorable Tolashe.
Thank you very much, Honorable Chairperson. Honorable Chairperson, my first question to the Chairperson of the board. I just want to hear from him whether he understands how the SABC is being established according to the law that governs this country. Because for me, in my mind, when he raised in public the fact that the political parties should not be involved in the dealings of the SAPC, then I had this question that whether the Honorable Chair in fact understand how the SAPC is established, because in my understanding, these are the people who are responsible to make sure that the constitution of this country is being implemented, and correctly so. And therefore, they have a responsibility to oversee any institution that has been established according to that constitution, to make sure that they are able to really do what they're expected to do. If yes, if he understands, is he prepared to apologize to the 50 million of this country? Because for me, what he said was, or what he did was a total disregard of the citizens of this country who went through a very difficult situation to make sure that the 1994 agenda is being achieved. And those are the people who are the most important people in whatever we're doing. And if he said, in fact, he said what he said on the TV, does he understand the implications? Because for me, that was the total disregard of the very constitution that established all these entities. Secondly, Honorable Chairperson, I hear the report saying they've tried to implement the Public Protector's report. How far did they go? Because I'm seated here with a huge document that talks to all that. Can they rate themselves to say, we went 10%? Because for me, the only issue that I see they've tried, we'll judge them later if we're happy on how they've really tried to, is the issue of the Mr. Motsoeneng thing. But everything else has not been touched. There are monies that are questionable that needs to be recouped from different people for different reasons. I don't hear the report talking to that. And the last one, Chairperson, the appointment and the suspension of the GCEO. In that one, Chairperson, I just want to hear whether there's a policy in the SAPC to get involved into all this, because I get to hear that at some point the court find that he was incorrectly appointed. The management, whoever responsible, took a decision to reappoint him to another position. Whether this is in line with the laws that govern this country, because we know how this process is supposed to be followed. Whether it's SAPC or the National Assembly or anybody else, there should be a process that really is put in place and agreed upon to say, when Tolashe is being removed because she has been appointed wrongly, then there's a process of advertisement and looking for a suitable person. But as I read from what the chairperson has just reported, little of that has taken place. And if it did, can you tell us really in detail, how did it happen? Because this creates a problem for me. Hence, I agree with the member that says, when did this happen? Because you might have an impression that this was just an arrangement between friends. When she's dropped in this position, then you can quickly overnight rearrange so that you can give him the same salary and the same package. I don't want to conclude as such, Chairperson, but I want to get the detail on how did we get there. Thank you, Honorable Chairperson.
Honorable Mbinda.
Yeah, thanks, Chair. Yeah, without repeating what other honorable members have said, I understand that we should be dealing with policy-related issues here as the honorable members. And I am not sure, I'm sure when you give your response, you will be obviously giving us clarity on your recruitment policy to answer some of the questions that have been asked, and also your remuneration policy. You see, because there are so many issues that have been raised, And I don't want to see myself, involving myself in such issues. But at least if we can be cleared as the committee. And also this issue about Undade Hlaudi, maybe you need to explain to us whether he has actually misrepresented his qualification. You see, I don't want only to deal with the issue of metric, because I understand that these days, if you have your NQF levels and they are equated to M+3, M+4, then it becomes now a different ball game. So I just want you to explain so that we do not, I understand the findings and I understand of the public protector that they have never been, you have never reviewed them in court. And then immediately you don't do that, then that's where the problem is. Then they become now binding as what other honorable members. But I'm just saying in your response, you just clarify those issues so that at least by the time we get out of here, at least we know exactly what actually happened. I will not go to other issues, but if you are seen now to be slanting the system, the very system, then that's where the issue of your fitness comes in, and I'm sure you know, in terms of your fiduciary duties, that you should not be doing that. Thanks, Chair.
Thanks, Africa. Honorable Motsoeneng.
Oh, I thought you were going to take some time to get to me. No, Chair, I just wanted to raise the issue of corporate governance. You know, the report seems to be dealing with superficial issues of who's responsible for what and so on and so forth. And I think the board is relying on a legislative loophole, that there's a certain level at which Parliament or government cannot interfere as a shareholder in the SABC. But I think there are much bigger issues. The King 3 report and the OECD recommendations on corporate governance in I think it's chapter 6 that deals specifically with the board, the role of the board. It says that the board must act in the highest ethical standards and act in the interest of the shareholder. And I think that's the key issue we need to consider here. The ramifications of what you do as a board, I think go beyond the responsibilities of government or parliament and so on and so forth, which the board seems to be hiding behind. The public protector report has recommended, or at least has made a finding, that there was fraudulent act in the appointment of Mr. Motsoeneng. If you then go and reappoint the same person whom the public protector has found to be fraudulent in another position in the same organization, your corporate you've literally gone over your corporate governance principles, because it means that the credibility of the organization that you represent or you preside over is now in question. And that I think that is the bigger question that needs to be dealt with here, beyond legislation and who's responsible for what and so on and so forth. You need to look at, as the board, your responsibility in corporate governance is to protect the credibility of the organization. That is the first point I wanted to make. The second point is that it's said that we come to sit and listen to the board to give us a proper report, a full report on their actions or their response to the remedial actions by the public protector. And they come here and give us a report on one issue of one person. I think it shows the level to which Parliament is not taken serious. You know, you're just here literally to come and protect one person, when there's a whole host of issues that you are supposed to respond to. I think that at that level, Chairperson, we need then to question the motives of the board coming here to speak in front of Parliament. Thank you very much.
Yeah, it looks like all members have spoken. We're going to take responses. And then after that, break for lunch. Hopefully, the restaurants are open, because you pay for your own lunch. Whilst the board is preparing for responses, I wanted to alert you that you will dig deep in your pockets for lunch. Professor?
I want to deal with the last matter, where it is being said that the board didn't respond to a whole host of issues. Chair, I want Company Secretary to read the letter sent to me on the 26th of September and another sent to me on the 30th of September. Then honorable members will judge me whether that whole host of issues were not addressed. Can you please, they are very short. Can you read those letters, Company Secretary? The one dated 26th of September. As she's still trying to get the document, let me deal with another matter, that of one of the honorable members who stated that 53% of SAB staff members resigned. If my calculations are correct, we have over 4,000 staff members, and 53% would amount to plus or minus 2,120, if my calculations are correct. We don't have that number of resignations, Chair. That is why I, from time to time, say we should be mindful and careful of what we say, because the facts that we have and the evidence that we have, we can provide this committee with that hard evidence that we never had over 2,000 resignations. Dealing with the issue of the public protector, Chair, we have on several occasions indicated that we have taken her findings on review. And this is what I want to also mention today, that the matter is sub judice. It has been taken for review. The same applies to the appointment and removal of board members. That is also sub judice, Chair. Those are court matters to adjudicate on. When it comes to other issues, Chair, whereby now certain things are raised which were not part of the brief from your letter, I would request that we be given ample time and we will respond in writing. The issue of 400 million loss, next week, Tuesday, we are tabling our annual report, Chair. It can be addressed there. It was not part of the brief. I hope the company secretary got those documents. Please read them.
This is
Can questions be responded to? The letter can be read. I know that.
I'm responding to the questions, Chair, because a perception is being created that there was a whole host of issues which were not addressed.
Okay.
And your letter, Chair, outlined those issues.
Yes.
So I want members to know those issues which were outlined and those that they are referring to as a whole host of them not being addressed. That is why I'm saying they were not contained in your letter.
Okay.
So I wanted to demonstrate that the issues that they are raising, Chair, are not contained in your letter. So I don't know which whole host of issues have we left out in our response.
Okay. No. Honorable Kongwela.
Thank you. I think the chair of the board must take this committee very serious. You wrote a letter, it's correct. But they are a board which is seized with these activities on day-to-day basis. To say they will only answer things that are in the letter, it boggles one's mind. And I think the chairperson of the board must be advised that the committee understand what their job is and what is expected to be known by them on day to day. He cannot say he will only answer what is his. There are issues that have happened, thousands of them. And I think he must be advised to respect the committee.
No, Professor.
You know, Chair, the problem is that one wouldn't know, Chair, what is in the minds of honorable members. If we knew, Chair, with due respect, we could have.
Just hold on, Professor. Just hold on. Honorable Tsedi and. Because I think the professor is shall I say, messing up the meeting.
No.
You know, you are disorganizing my meeting as the chair. Honorable members, the professor is disorganizing my meeting. We wrote a letter. We specified the issues. But we cannot write everything in a letter for people who are handling matters of SABC. You know, there are so many questions here that we cannot put in a letter. We say in a letter. These are the issues to respond as the board. But you can't confine yourself to those 5 issues, whereas you know your scope of operation as the board. I think that's what the members are saying. Honorable Tsedi.
Honorable Chair, my take is that we have invited the board to this meeting. We did not invite the chairperson of the board to this meeting. There are 3 executive members who are as well part of the board, who can as well, in their capacities as members of the board, try and clarify some of the issues raised. So all I'm saying is that the chairperson should not find himself in a problem where there are situations in which some of the issues can still be handled by some other people, including the 3 executives, acting GCE, acting CFO, and acting COO. In my understanding, they are as well part of the board. So all I'm saying is that let him allow the rest of the members of the board to clarify some of the issues. He's not in the position to deal with some of them. Thanks.
Honorable van der Merwe and Honorable Dolash.
Thank you very much, Chairperson. I want to align myself to the previous speaker. Parliament is not in session at the moment. You had to specifically request for us to meet. This is an issue of national importance. The SABC is facing a crisis. Parliament is currently closed. We are convened here to discuss the issues around the public broadcast. It cannot be that when we've specially applied to discuss issues that concerns the public, that the chairperson of this board tells us we can discuss it next week. There's not going to be a next week. The next week we'll discuss other issues. We are here to discuss governance. We are here to discuss Mr. Motsoeneng's appointment and other issues. If the chairperson feels uncomfortable to answer questions, he's got his entire board here that can assist him to answer the questions. We have set aside time specifically for this. And please, he must respect this committee, please.
Can we do that, members, without delaying the meeting? Can we allow other members of the board, if the chairperson is unable, because I must emphasize this, if the chairperson of the board is unable to answer some of the questions, there is a whole delegation of the board here. Delegate, chairperson. Delegate to your members of the board.
Let me allow acting GCEO to respond to some of these matters.
Thank you very much, Chair. I'm going to select a couple of matters that I can talk to, because to be honest, there have been quite many. So I'll try and just select those that I can talk to. Then my colleagues, as Chairperson has said, we'll talk to the others. The first thing that we need, that I need to talk to would be probably the question of Honorable Self, where he stated that the legal costs of the SABC has increased from 171 million to 250 million. I imagine that that's an extract from the annual financial statements, which we shall deal with in detail next week. But let me just say that that amount of disclosure in that note is not actually for the cost of, it's not the cost of legal fees. It's actually legal claims against the SABC. So it's a provision for legal claims. And what that means, essentially, it's an accounting term that refers to a liability of an uncertain amount or timing. So what happens is that the SABC could be sued by anybody for whatever reason, and we're saying that when we compile all the cases that the SABC is exposed to, then the lawyers will tell us that if everything went against us as the SABC, the potential liability is prior year, which was 14-15, was 171 million, and they're saying it's this year their estimate of the same liability is 250 million. So it's not the cost of paying lawyers, it is the potential cost that the SABC will be exposed to through if litigants claim against the SABC. So I think that one needs to be corrected. It's not the price, or rather the cost of paying lawyers. I just need to put that to rest. Then the second other matter that I want to talk about, I know we're going to have a detailed report on the annual financial statements, is I think Dr. Mulder talked about 53% of employees resigning. That's not true. What it is in the annual report, 199 employees left the organization in that financial year. Of those, 53% resigned. Now the question is, why? We came here and said that we had a situation where there was medical aid fraud at the SABC, for which 123 people were implicated. Some of them chose to resign. So it's not correct that 53% of the total population resigned, because I can tell you in 14-15, we had 3,875 employees at the SABC. This year we have 3,835. So there's no possibility that half could have resigned. Let's just put that to rest. The other issue that I want to talk about is around the King 3 responsibilities. My former mayor of Ekurhuleni, now honorable, talked about King 3. You're right, King 3 it's imperative that we comply with King 3. But there are a couple of issues in this scenario that we are faced with. The first one is the public protector issues a report that has a series of findings. And we as the SABC then go to court, and remember at that time we were not sure whether this report was binding. So the Constitutional Court says, yes, it's binding. But it says that after the fact. Despite that, we looked at the findings and said, the findings are affecting an employee of the SABC. Employee who was deployed currently that time as the COO of the organization. So we said, if you are the COO, here is a report that has found you wanting. So what did he do? He stepped down from the position for about a week, or I think it was 2 to 3 weeks, to face a disciplinary session. The disciplinary session at the SABC or process works as follows. If there is a charge, you get the Employment Relations Group, which we call ER Group, to press charges. Now, because of the nature of the event, it was a very serious case involving somebody who was very prominent. We said, we don't want this to be contaminated. Let's look for an independent prosecutor or initiator in this word. In this case, let's look for an independent chairman. And we got an advocate to chair the process, and we got some other person to prosecute. To make sure that it's independent, we did that. That's at one level. Second other level, we said that you will also make it public, such that the public can see what is happening. We went through the process, and remember that the report is not being contested here. The SABC is not contesting the report. The report is there. We say that now that you are found wanting with this report, it becomes an employer-employee issue. And we appointed an independent advocate who took the organization through the process of disciplining Mr. Motsoeneng. He comes out with findings and says, not guilty. But in the process of the disciplinary, certain witnesses were called in to testify. And we found that there were disparities between what was in the report and what was ventilated at that disciplinary. And that's what triggered a review of the public protector report. So we have taken it to court for review. It's not saying that we disrespect the report. We're saying, as part of ventilating the charges against him, certain people denied, for example, being interviewed, and we said, all right, we will take the report for review. However, the conclusion of that disciplinary was that he's found not guilty. I sit here now as the GCO with a disciplinary, transparent. You may want to call it a farce, but that's another matter. If you want to call it a farce, and you have said that you have taken it to court, so that is a court matter. But before me is a report from an independent chairperson saying that he's not guilty. What do? Immediately I consult my legal team and ask them, in light of the SCA judgment setting aside his appointment as COO, what is the status? They say, you cannot face a disciplinary if you're not an employee, first of all. So that is settled, in fact, that he's an employee. The case was not about whether he's an employee or not. It was about the process elevating him to COO, which has been set aside. So the legal opinion I get is that you put him back in his old shoes. We look for his old shoes. It was an executive director, a group executive, corporate affairs, which was stakeholder relations. So we, as we have said here, looked around and said, as an organization, where is the best place to put Mr. Motsoeneng. No one in court or any public forum has said that as group executive stakeholder, which is now corporate affairs, is incapable of doing that job. So it only came to reason that we put him back where he belongs. The incumbent there is Bessie Tugwana, capable broadcaster, and we have projects, a couple of projects that we are running at the SABC, many of which include, the list includes the following. We have the DTT project. We have the project to introduce local content, specifically on SABC 3. We have the issue about new businesses, because we are looking at our revenue streams and we're seeing the traditional revenue streams of advertising and TV licenses have reached the peak. So we're looking for new businesses. Of course, we can't share that with you here because it's information that is of commercial sensitivity. We have a project to look at the alignment of the organization, SABC as an organization, because as a result of the findings of the Auditor General, many of them were because the organization had grown and systems had mutated in such a way that we had silos. So we are reorganizing it. That's why you'll see name changes happening. Stakeholder and provinces is now corporate affairs because we found there was a misalignment between stakeholder and provinces and marketing. They walked in different directions, yet they were doing the same thing. So there are these projects that we are implementing. Another one is the transformation specifically around supply chain management in the areas of information technology and technology supply. These areas have not been they are not properly representing previously disadvantaged people. So those are things we have put in projects. We said, Bessie then can move to that project office because the board approved a project management office in the GCO's office. So she was placed there. So in short, I, as acting GCO, was in a quandary. There's an employee-employee matter at hand that arises from a public protector report. The employee is taken through a disciplinary, and the employee is found not to be guilty. What should I do? The only reasonable thing at that time was to put him back in his old shoes. And my legal team gave me that advice. The issue is about...
You said the only thing you could do?
Only legal. Legal gave me an opinion that legally you cannot put him in any worse position than he was previously. The set aside from COO meant that he gets away from the COO position, but he's still an employee. So put him back in his old shoes. So we look at it as a business and say, what is the best place he can be? And remember, no one, whether it's a court or even the board, has found him incapable of doing his his job as GE Corporate Affairs, what was previously his role of stakeholder, with an addition of marketing. So it's in this light that we say that this was the best decision that we could take. Somebody has asked, what is his salary and what? I'm a bit sensitive in this area because that's also in an employee area. Suffice it to say that if you look at the annual report, which will be ventilated next week, his salary is reported there as an executive director. But the negotiations after the set aside is something that I would be very coy in talking about because remember it's a sensitive issue between employer and employee. Thank you very much.
Yeah, they are still responding, Honorable Shafam. Doctor?
Thanks, Chair. The question on DC charges, disciplinary hearing charges. The charges we followed, because the question was we drafted the charges, how did we do that, and we followed what? all the charges we followed for that or prescribed to the DC committee were listed by the judge. So we gave them that as a brief, that the judge wants you to look on 1, 2, 3. Within draft hours, everything was from the judge. Then the issue of asking for the report from the disciplinary hearing. Yes, we'll submit that to this committee. On our side, we have put that report online. So since we finished the DC, we published the report online. So it's already there for public consumption. The chairperson, I think I have to emphasize that we, as the board, are appointed by this committee. And through our shareholder, who's the Ministry of Communication, we account to this committee. And we report to this committee. There was a question of meetings for the board and do we correlate and what? If you check on our annual report and maybe the company secretary has the figures, from all odds, we have met all meetings that any normal or formal board will have met. There's no non-compliance of meeting our committee meetings. That's board meetings and committee meetings. And I want to emphasize that, honorable members, when we came in as the board, we were given task to turn around the SABC. We were given a task to pay for the loan that this committee granted us through Nedbank. And any board in any company or any institution that is in crisis, chairperson, will not meet the minimum compliance of governance. I understand the honorable member was mentioning the company law and King 3. And this is what, through our company secretary, in each and every meeting, we're reminded for. And we stress this and emphasize to our executives to flow this down, the compliance. That is why even today, if you call the Auditor General tomorrow, which when we arrive as this board, the SABC was not audited by the Auditor General. It was an independent company. We are the ones, this board, that brought in the Auditor General, because this is the auditing voice of South Africa. If you call them tomorrow, chairperson and honorable member, they will tell you about the adherence to the compliance of this board to run the SABC. Now, if a board is told about crisis, first thing that comes to your mind is governance. And that will reflect on your reportings. Do we submit the quarterly reports, chairperson and honorable members? Yes, we do. And in all, each and every quarterly reports, that's where your governance, your overseeing, your financials will be reflected. So as you mentioned, chairperson, that maybe some of these issues will need to be categorized so that we come and clear them one by one or by groups. Because maybe when we submit a report, there's no enough time for honorable members to go through it as a report. So we did the first two mandates that we were given to pay off the loan and to turn around the corporation as this board. If there's an issue of implementing the public protector's recommendations, I remember when we arrived, I think it was 3-4 months down the line as a new board, we were thrown with this report. And we can't sit here and say it doesn't belong to us. It belonged to us. That's why we drafted the implementation plan and sent to the public protector in 2014 to say, public protector, this is how we're going to implement the report. And the public protector gave us the response that I have received your implementation plan. And all these, Chairperson, we report them on our quarterly reports when we bring our quarterly reports here, that we have drafted the implementation plan. Now, where we got stuck with the public protector's report, Chairperson, is the highlight that we received during the disciplinary hearing as instructed by the court. Remember, the disciplinary hearing is from a recommendation of the public protector's report. I understand that some of the members were saying we formulated the DC or we came up with the DC. It's part of the implementation to the public protector's report. Then we got instruction from the court, from the judge, to say, I want you to conduct the disciplinary hearing as recommended. That is why we were even mentioned on the Constitutional Court when the chief judge was giving the verdict about Nkandla, that the SABC implemented the recommendation of the public protector by conducting the disciplinary hearing. We were mentioned there. So I don't understand if members have ideas of we don't want to follow the public protector's report. Then we followed that. We said to the independent panel, we don't have to formulate. Remember, we are contradicted in this issue. The judge has stipulated, we said as the board, do we agree that as is from the judge, these are the charges, we're going to give the brief to the disciplinary hearing. And it was done. Now the highlights came during that process, Chairperson, that from the 14 witnesses, almost the top 4 or 5 of them, if I'm not mistaken, they said when the investigators of the disciplinary hearing, calling them to say, look, this is per instruction on the recommend, this is the report, come and witness. They said they've never met any investigator from the public protector. They have never been consulted. One of them gave us an affidavit, Chairperson, which is here, that no, you're calling me for the wrong things. I, in fact, went to the public protector to complain about the acting CEO, Mr. Nicholson. Here is my complaint, not to Mr. Hlaudi Motsoeneng. So I'm implicated on the wrong report. So that's where we started to be puzzled to say, what is happening here? Because from the 14 witnesses, I think we received 4 or 5. That is why now when the report came of the disciplinary hearing and cleared Mr. Motsoeneng, we said as a board, now we're sitting with a problem here. We seek for legal advice. You see, this is showing you and this House, Chairperson, that how compliant we were following our steps. We didn't sit as a board and said, yeah, which step do we go? Let's take this to review and what? We ask for the legal advice. And now, whether the legal company chairperson or the legal team that were appointed is whose firm or what, but we seek for the legal advice. That is why we took this to review. On top of that, chairperson, we're still following, even though this is on review. That is why now when this appeal set down the position, appointment of Mr. Motsoeneng to the COO, we followed it. We told him to step down. Now, the legal minds will tell you, chairperson and honorable members, that when the judge rule or the court rule to step down the appointment because of irregular procedures or whatever mentioned there, the court or the judge is not stepping down today. It's not stepping down when the court or the judge was announcing at that date. It's stepping down the appointment. So which means the first day while you were appointing that person. So now that's where you looked at the labor relations. Who was that person when the judge stepped the appointment of the COO? That person was the employee of the SABC. That's when now, as the board, we said, executives, this is your person. From what, as the board, according to Broadcasting Act, the board recommends to the minister the three executives, the COO, the CFO, and the CEO. Then we said, from our side, where we recommended the appointment of the COO, where we were in charge of this level of the Broadcasting Act, the court is saying we have followed irregular procedures. We're stepping this employee. Had it happened that chairperson, Mr. Motsoeneng, was an outsider, we were going to consult Mr. Motsoeneng and said, our employees, now as the employer and the employee relationship, where we employed you as the board, the court is saying it was irregular. Then and sort it from there. But now the position here of setting down the legal readings and interpretation is that this person, as the employee of the SABC, where you board took over and appoint him to the COO, I'm setting that as irregular. So that is why we handed it to the executives to say, he's your employee. And that's what the acting GCO was trying to explain, to say he looked for the legal advice, to say now I am faced with Labor Relations Act. And now Labor Relations Act, internally, I will assume, as the CEO myself, the previous CEO, I will consult my HR, my ER, if I have that, or labor relations, first before I even get a legal mind from outside or advice from outside. So I think that's what the acting CEO was trying to say, Chairperson. So all of the other questions that is the board fit? I think from where I'm standing, Chairperson, when you want to analyze and assess the fitness of the board, you analyze it and assess it from compliance. Because compliance will give you the company law, will give you King 3 code, will give you PFMA, and all related acts and legislations. That's where you'll analyze the fitness of the board. Yes, you're right, Honorable Chairperson. The fitness of the board is not analyzed or assessed through individual ideas. It's analyzed through governance, as we have mentioned, as other honorable members were mentioning there, and compliance. So once you don't see any light of compliance to the institution, which is this authority, this house, that's when you start to trigger problem, that this board has a problem. So, Chairperson, I think from my side, those are the few I try to highlight and answer. Thanks,
Thank you very
Chairperson.
much. We hear you, but leave that question to the members. The question of fitness of the board and all of that. The members will engage, but thanks for your contribution on it. Members, it's now time for lunch, unless you want us to run to 5 o'clock without lunch. Can we break for lunch 30 minutes? So meaning we'll be back at 2. Thank you very much. Uh, Hello? Members? Member Tolashe? Members, I'm going to hand over to other members of the board to reflect Ms. Tugwana, Ms. Rapela, Mr. Naidu, Mr. Mavuso. If you can start with you, Tugwana, if there are issues that you want to respond to or issues that you want to raise, because I really want us to have a view of all of us so that you leave the meeting having spoken.
Okay, thank you, Chair. There were two issues which I think my colleagues have not touched on, which were raised. The one issue was around how the operations have been affected by the changes. Thank you. At the SABC, we haven't been affected operationally. And the one way that you, from a public perspective, can realize how we are affected is when we are not able to show you a picture from a television perspective, or for you not being able to hear the voice from a radio perspective. So up till now, as I'm speaking, our operations are running efficiently and effectively. Then there was I think it was more of I think it was more of an insinuation that because there's an allegation that the then COO was given an increment 2 or 3 times, it affected the general staff, that the general staff did not get their due increments, annual increments. So I just wanted to correct that perception, because we have been, as SABC, been able to offer our staff annual increments. And this is not from our own decision. This is an engagement with our trade unions where we decide after long, often protracted negotiations on a percentage that they feel, well, comfortable with. So it is not true that our staff have not received an increment. In not the past 5 years that I've been an executive at SABC. Thank you.
Thank you, Chair. There was a question of what is the board doing in terms of filling the vacant positions. And what I want to clarify is that there's only 2 vacant positions, at the GCO and the COO, because Mr. Aguma's permanent position is the CFO, so he is acting GCO at the moment. I'm sure members are aware that there was an article in the paper this past weekend of the position of the acting of the GCO, so that process is unfolding. The one for the CEO will be advertised in the near future.
Mr. Naidu.
Thank you, Chair. The presentation, Chair, that I saw today was the first time as a board member I was seeing it. I wasn't party to it. So I thought what I should take you and let you know is that if I was party to it, I would have made the following contributions to some of the issues that are pertinent that you raised, and I think some of the honorable members raised earlier. And the first one, very simply, it's around Mr.
Are you saying
Motsoeneng's.
you didn't contribute to the presentation of the board?
No, we have not met as a board to put this presentation together. I'm not sure who put this together. I know it's being done in the name of the board, and as a board member, I suppose I must abide by that. But somebody put this together somewhere. So all I'm saying is that had I been part of that, I would have informed this committee and you, Chair, about 3 issues coming from a legal perspective, because that's what I am. I'm a lawyer. The first thing, very simply, is the Western Cape judgment. You had a judge saying this appointment was irrational, full stop. Right, so that means at that point, had you not taken a further legal recourse, it would have meant that the incumbent was no longer an employee of the organization. That is the effect of that judgment. But by going on appeal to the Supreme Court of Appeal or applying for leave to appeal, what you in effect do, you stay that judgment. That means for that period of time, you are still an employee until the SCA makes a decision. That decision was made a few weeks ago, 2 or 3 weeks ago, where the SCA said there are no prospects of appeal. Now, at that point, that's the final door, as we call it, you are no longer an employee of this organization. There's no other explanation for this whole thing. So as simple as that. The second point is that the SCA decision has nothing to do with the Motsoeneng as an employee. I mean, that is absolute nonsense. I mean, whoever gave the SABC that advice should be shot. The third point is around the delegation of authority. Now, I think whoever is advising the board, it could be our internal legal department, there's a reference to clause 13.8.1 which says that the powers to delegate are given to the chief executive officer in terms of the DAF, delegation of authority framework. Now, that's a very simplistic way of looking of delegation. You know, when you talk about corporate governance, firstly, that's the power given to you. Yes, that means you as the incumbent can make a decision. But the next point is in terms of what framework did you make that decision, in terms of what employment policy, in terms of what employment procedures, that is not answered. And that's the question that leads to what we call irrational, or what I call arbitrary exercise of executive authority. Now, there's a famous case that goes back about 15 years in this country called the pharmaceuticals case, which laid down the principle that when you give power to an executive, like a CFO or a CEO or a COO, there's a duty on that incumbent to exercise that authority in a judicious way, with understanding of all the complexities that go in making such a decision, and not in an arbitrary way. So when you exercise power in an arbitrary way, which happened in the case of Mr. Motsoeneng being appointed as Chief Executive Corporate Affairs, what I'm saying is that there was no proper procedure followed. And listening to the CEO here where he says, well, somebody gave him advice who said, you know, maybe we should put him back in his previous job. I mean, you know, when I listen to an executive at this level talking in such mundane terms, you know, it actually makes out the case why this board should be dissolved. You know, I mean, you don't have to sit and make an inquiry. Just by listening to the inputs of some of the people that went before me, you are dealing with people that don't really understand what is corporate governance, in my view. And I'm speaking as a board member. You know, it gets frustrating as a non-executive board member when you give advice from time to time at the board level, and then it's either refused or turned away, and one is not sure why. And if I go back to a few incidents in September 2013, one of the first challenges we had was this contract with MultiChoice. Now, the board gave me a task of looking at that contract, which I did. And I said to the board that that contract is illegal. It's unlawful. And what was the response? Not to review it, but to get a second opinion from some senior advocate to discount what I was saying. So that's been the dysfunctionality of this board, unfortunately, since that time, you know. And I think the point that we're missing is that there are a couple elephants in this room, you know, and you know, what we're trying to do here as a board is trying to skirt around those elephants and deal with compliance issues in a very superficial way. And I think that's a bit disingenuous, not just to this committee, but to the South African public and the taxpayer in this country. So that would have been my contribution on those three matters pertaining to Mr. Motsoeneng. They are very simple issues, so let's not complicate simple matters. The second thing, Chair, is that you know, we've had the Public Protector report now since, I think, February 2014. And it's very clear that those were binding judgments, and had you had a different opinion, the only legal alternative was to go and review to a court of law. So a court of law had to set aside those findings. And I think the unfortunate part in the SABC was that we've had a kind of long process in order to undermine what was said by the public protector. I thought that was legally wrong. And I've just heard from my colleague here that we are now going on review, which is like almost 2 years after the event. Now the law is very clear. If you want to review in terms of PAJA, you must do it within 180 days. You can't go 3 years to a court of law. I want to review something in 2013. You must have a good case to make out to judges. They're not going to listen to you and wait for you to come after the event. So let's be mindful of that process. And I just want to end by saying, Chair, that I mean, I've heard all the explanations and I'm not satisfied as a board member. When I look at this presentation, it was amateurish in my view. So I think my own position is this, and I want to take my cue from Honorable Shabambu when he said earlier in his input, what are we doing here? You know, some of us have come through some serious struggles to bring this country to the point where we'd like to give a better life for everyone. And here we are sitting discussing and spending valuable time discussing mundane issues, you know. I've come to the conclusion that this board is dysfunctional. It should be scrapped. And personally, I will be resigning today as a board member. Thank you.
Mr. Mavuso.
Thank you, Honorable Chairperson. I just want to touch on a few points which I believe are very crucial that require attention. There was a point mentioned here that this board dismissed a number of board members in a manner that was quite unusual. I must make it a point here and now that it's something that really pains me because I was against that decision. And it is said that we speak about the late Hope Zinde, who was one of those members. And very credible auditors, if I may use the word, Ronnie Lubisi and Rachel Kalidas, who added value into the audit committee to a very large degree. And I'm actually at pains to say, I'm wondering what is happening as we're seated here. The second point I thought I should raise is with respect to the kind of dysfunctionality that has come to the fore. And indeed, by the way, the presentation that was presented this afternoon or this morning, I was seeing it for the first time too. I was not party to it. I was completely flummoxed when I saw that. And I said, what is happening? So there seems to be some kind of isolationist approach to ostracize certain board members for whatever reason I may not know. But what is crucial here is that I do believe that I made it my point because I had the public interest at heart to ensure that the public corporation does its work accordingly. But of course, in certain or in most instances, things had to come to a hit whereby we have to vote on issues, and more often than not, we never agreed. But what is important, Chairperson, is that some of the processes that one has observed really leave much to be desired. I'll just give a few examples. To date, we have no fewer than 11 executives having been offered severance packages. for whatever reason, and these have never been brought to the attention of the board because I heard about them through the grapevines. And my worry here, Chair, is that it's nothing short of institutional genocide. Because you have people who've got institutional memory who have been ostracized or taken out of the institution for whatever reason, and for me that is very worrying. I'm worried to say what is going to remain now that they are gone. You're going to have musical chairs because the executives will then do whatever they do and appoint people from within. Whether that is going to be credible or not is another matter, and that for me is quite worrying. Coupled with that, you then have a situation whereby, in case you maybe you're not aware, Ma'am Pesik Tugano has been appointed as acting COO. I only heard about it today. I was not party to that recommendation that went to the minister for her to be able to give ratification to that. Because ordinarily they would have a round robin to ensure that each one of us expresses a view or an opinion. I don't have anything against her. I'm merely indicating a process point that says that we're not following due process, and seemingly it's very clear that a particular picture is beginning to emerge, and it's actually worrying me. I cannot afford to be party to that. And for that reason, Chair, I believe that seemingly my contributions are not adding much value, and it's more the reason why I've come to the conclusion that I'm tendering my resignation today.
No, thank you very much. Thank you very much, members. You know, earlier, I said to the board, as they speak and as they respond, they must talk to the quorum of the board in taking decisions. I think I was clear on that one, and maybe those are some of the issues that are very relevant for the committee. Let me start this side. Honorable Gongobele, Honorable Tolashe, Honorable Van Skalvik, Honorable Self, Honorable Tsedi, Honorable van der Merwe, Honorable Madisha, Honorable Shibambo, Honorable Munkwena, Honorable Kekana, Honorable Machoba, and Honorable Kalako. Honorable Van Dijk.
Thank you, Honorable Speaker. Thanks, Honorable Chairperson. I think there is no better time to ask a question: is the board fit to do the work it's doing? After having listened to a series of responses, you see, here is this board. It decided to appoint Mr. Motsoeneng in whichever, let me say, for lack of a term, to place him wherever they have placed him, whatever they call it. Now, the same board is saying to this committee, we are reviewing, we have applied for a review. I want to conclude that, I want to say this board then understands that the remedial actions of the public procurator, a judicial institution, must take a decision. And remember, these things that you are asking them to be reviewed are affecting the same individual you have what to call, you have placed. But you know that they have got no standing in law until they have been reviewed. But where we are sitting, the individual is already at work. Be reminded, if you read the public procurator, has got serious allegations against Mr. Motsoeneng, who, by the way, I should let him know, even if, Chief, I die having never been covered by SSB, You know, we have lived without that thing for more than 40 years, trying to fight for this country without SABC covering us. So I don't know what the board is owing Mr. Motsoeneng. Maybe one day they will clarify. The allegations against him are serious. Now you say you had a DC. You had a DC. There's this common word that is pervasive in your presentation that witnesses did not come. But you have not answered the question clearly, positively. As far as we are concerned as SABC, Mr. Motsoeneng was not involved in illegal promotions. You have not said that. That is the first point. It's what we call objective facts, positive statements, so that you can actually hang your heads for that. So he has not done that. Say that he had no role in the fraudulent appointment of the CFO. Say these things. If you are a self-respecting board, you must say the DC had no findings, but as a board, whatever happened in the DC, based on our knowledge, these things did not happen. Not a single one of you has been brave enough to say that. All what we are hearing is that witnesses don't come. But if you look at the report, there is one report where Mrs. Swanepoel is quoted as having said she had an interaction with Mr. Motsoeneng, and Mr. Motsoeneng had a particular view about the role of Mr. Swanepoel. And Mrs. Swanepoel had her own view about that. Now, the point I'm making is that you have not come, say, irrespective of how many witnesses came, your own conscience, based on your knowledge as the board, has Mr. Motsoeneng done the things he is said to have been done? Forget that you are messing up with the law, that you are reviewing the remedial actions of the public procurator against which you have already implemented some of the things that would actually contradict the spirit and letter of those remedial actions. So to me, that's the board which has got disrespect for South African law. It's got no regard for it. It doesn't care what happened to it. Now you tell us that Mr. Motsoeneng has got unique skills. You know, every time I hear this question, it worries me because, you know, let me tell you this. If Verwoerd offered artists of South Africa in the 80s 90% and said, I'm giving you 90%, but apartheid continues, there's no way you would have accepted that. Because Verwoerd at that time would be addressing the material issues, the tummy of ourselves, not that which defines us. If you've got a COO who implement rules that undermine the founding principles of our democracy, because he's giving 90%, there will be food at night. So that's what defines us. We don't need democratic principles. What we need is food. It's only Verwoerd who would have spoken like that to us. And we would have told him, we reject that. Now we're told by Ms. Tugwane that SABC is operating. I wish she was going to make her view about how does she understand the view of society about the SABC today. The people who are praising SABC currently as we speak, generally, are the people who generally seems to be getting something from SABC, either in group form or individuals. But the general society, where I'm yet to hear the survey of society about SABC. Now, how do you explain a situation where two board members do not know what the chairperson is saying? How on earth should we look at that and say it's a normal thing? Why should we call it a normal thing? Instead, you've got conferences, like cowboy conferences there, people having bought, I don't know, new clothing, parading in this country, remonstrating with the political leadership of this country, demonstrating that, bordering on saying that it can go to hell. And then you think we must sit here and say that is normal. There's a lot of sacrifice that is made for this democracy. There are orphans, there are widowers and widows for it. And it was not secured on tummies of food. Because what was being fought for is the identity of this country and the founding principles of our democracy. So because I'm giving you 90%, keep quiet. So I'm saying we can do without the skills that do not respect the founding principles of our democracy. Now, your DC met, your DC cleared. Now ask yourself this question: what are you trying to do now when you're applying for a review? Because the list of the issues that the DC was supposed to deal with are all the issues that the PP spoke about. You have already acted on that. Based on that DC, that has cleared all those things. You said, Mr. Motsoeneng is clean. And then now you are applying for a review. What do you want that to serve? Because the court of this country, the court has already spoken on this matter to say those remedial actions are binding. There is no other institution that can actually give a second thought except established judicial courts in South Africa. But what are you trying to do? Now, as you continue again to say the things that you're saying, I'm yet to be convinced that there is a reason why an inquiry must not be done around you. Because if you respect this committee, and you knew this committee wanted you to address them, a lot of issues that are raised, even in that simple presentation that you have, you would have supposed your common sense and your fiduciary responsibility was supposed to tell you that the committee might want policy on this matter. You were supposed to, actually, if you took this committee serious, you're supposed to have listed what are the possible documents that are going to be required as we make the following submissions. The fact that none of them have been put here, except that 3-paragraph protocol document, there is no better way to explain the disrespect you have for this committee than that one. Right? So all I'm saying, I pray that I don't think from my side I've got any further comment to make up against you, actually with you. Because I thought your response was going to assist us to think differently as against what we've been thinking, having seen a number of things. Actually, what you are doing, we are confirming that SABC is in trouble in everything that you have just said. So all I'm saying, Chair, I want to be convinced that there's a reason why there can be, the Sonnepool case only on its own, that's my last point. The Sonnepool issue, the fact that there are different views between Motsoeneng and Sonnepool, that alone calls for further investigation. The fact that Chair presents here and 2 board members have got a different view, that alone calls for further what to calling. I can list a number of issues that creates basis for further inquiry. There can be no justification why that is not done in my view. Thank you.
Tolashe?
Thank you, Honorable Chairperson. Honorable Chairperson, I was also sitting here when the board was trying to respond to the questions, hoping that there will be some response that will give the dignity to this committee and to this meeting. And unfortunately, the chairperson in particular decided to be sarcastic, and everybody else was unable to respond into even one question. Not even one question has the board been able to respond to, except for what Honorable Kungbele is responding to. And Chairperson, I'm not sure now with the last blow we're getting from the 2 board members, what else do we want now? I think this whole scenario is forcing us to put a question. If we are going to ask, what are we going to ask? Because a letter was returned to the board to come and respond. Here is a piece of paper presented to us as a response. To be even more disciplined and more of good members of parliament, we pondered putting questions. And the board, once again, was unable to respond to all those questions, very fundamental questions. And now, I'm not sure if we want to change ourselves to be a court of law. I think now we've gone too far. I think it's enough now. I think the time has come, Chair. You have been trying to avoid this. For us to ask a question, whether this board is fit for the office that they are holding. Because the first question I had is whether they understand the laws that establish this institution. If the chairperson will go and say, I'm not accountable to anybody. So that was my start of point. So I want to appeal, Chair, to say we should not waste time so that we are able to get to real issues. The pondering of the fitness of the SAB board into the office. Allow the parliament to do that, follow its processes, so that at least at the end of today, we can be able to talk to South African in a very confident way to say, we are dealing with your issues in a manner that you would love to see us doing so, because I don't even want to get into a situation, you know, unfortunately, Mr. Motsoeneng has been changed to be something that doesn't exist. I've never had a person being defined like he has been since this starting of this. I don't know, it's the first time, and I think it's so unfair to him as a person. I don't think we must get there as the committee. He is just a small matter within a huge institution. Therefore, we should not allow ourselves to get into pondering Mr. Motsoeneng as a person. Therefore, let's not even begin to get there. Let's deal with the tough issues. Let's deal with the board chairperson. Thank you very much.
Thank you, Chairperson. I think I've been broadly covered by the previous speakers, because my concern was also the questions that I've raised hasn't been answered except for the part that Mr. Naidu answered. So I think let's rather leave it there, because it's clear that we won't find the satisfaction that we need. And what we actually need is honesty. That's the only thing that we need at this stage. If we ask an honest question, we expect an honest answer. Because I've raised the matter of the position of the renaming of the same position. And I've clearly asked, did it only happen as a renaming of the position? Or was it an upgrade of the post? And how did it relates to each other, the previous position to the current position? I didn't ask how much the person is earning, but I wanted to establish if there was an improvement of benefits relating to the new position. Because we were told that they established it in order to improve deliverables. To which deliverables are we talking or referring to? Is it new or existing deliverables? And we needed some clarification. And it's clear that we are not satisfied in terms of the responses that we received. Thank you, Chair.
Thank you, Chairperson. I really want to come back to the issue of the so-called transparent and independent disciplinary inquiry, because it also went through a particular process. You will remember that Advocate Mukari was appointed the chairperson of that. Then he was replaced by an Advocate Edeling. There was an initiator called Mr. July from a very reputable law firm. He was replaced. So I have the most serious doubts about the independence and transparency of that procedure. And I think that there was deliberate manipulation of the presiding officers to guarantee a particular outcome. And I think that my colleagues have been absolutely correct, that there were a number of issues that were simply not traversed in that disciplinary inquiry, and therefore the outcome of that disciplinary inquiry is effectively meaningless. Specifically, the position of Ms. Swanepoel was mentioned, and I just want to read into the record exactly what she alleges in an affidavit. It goes like this. Ms. Swanepoel left the SABC in 2006. In late 2012, Mr. Motsoeneng telephoned her. He told her that the SABC was trying to fire him and he wanted to keep his job. He said that his attorneys wanted to make an affidavit about his matric certificate and the form that he had completed. He indicated to Ms. Swanepoel that she should say that he had told her that he did not have a matric when he filled in the form. She refused. She also told Mr. Motsoeneng that she did not wish to speak to him as she had a sexual harassment suit pending against the SABC at the time. He knew about the case and asked what she wanted from the SABC. She said she wanted 2 million rands in compensation. Mr. Motsoeneng, then the acting COO, replied in Ms. Swanepoel's words that, quote, he could organize for the SABC to pay me 2 million rands if I was willing to depose the affidavit about the certificate. That is the elephant in the room that was never, ever dealt with by that disciplinary inquiry. Never. And when you depose to that in a court case and it's not dealt with, then what type of inquiry were you thinking of when you did this? The other thing that really worries me is if the SABC board was so satisfied with the nature of that disciplinary inquiry, why did they oppose the review application that brought by the Democratic Alliance? And why have they now applied for a stay application in respect of the court case pending the substantive review of the Public Protector's report? And it might be true that the legal expenses alluded to in the annual report do not reflect the actual costs. But what we've dealt with here in this one case, 4 cases, 3 High Court cases, 1 SCA case. We've now got a review application, an opposition to the review application brought by the DA against the disciplinary inquiry, and the stay application before Judge Semela. How much is that costing the corporation? Just because of one person? I mean, it's outrageous. Chair, I think that I agree with the colleagues that actually what we've heard here today makes the board look like some sort of dog show, frankly. And I think we should move very swiftly to discharge our responsibilities in terms of Section 15A of the Act and recommend the dissolution of the board.
Honorable van der Merwe.
Thank you very much, Chairperson. I think we are all on the same page. I think the previous speakers have very succinctly captured where we should be going, Chairperson. But let me also then just briefly say that I think the non-answers that this board has provided us today with, it speaks volumes. Also, I want to thank the 2 board members sitting in front of us who have been brave enough and honest enough to tell us about the internal struggles that you are facing, and I think we need to thank you for your honesty. I think you have served our nation and this board very well, and I think you're probably the only mistake that you've made is that you've been too independent-minded, like the previous people who have been chased away, like Rachel Kalidas and the late Hope Sinde. So please, I think we must really applaud you for being so brave and honest today. I want to go back to the issue about the DC and some of the comments that were made around that. In terms of the DC, board member Tsumba said that one of the problems they had was the fact that they couldn't get the number of witnesses, or all the witnesses that were lined up were not available. But I think also if this was a hands-on board, you would have known that there's a culture of fear and intimidation at the public broadcaster. And that is one of the reasons that you couldn't get the witnesses to come forward, to have a credible process in terms of this DC. And also, I think we need clarity in terms of who this independent company was that conducted this hearing for you. You mentioned that acting GCO, because the fact of the matter, there was another company that had a disciplinary hearing as well, and they compiled a report which actually replaced the Public Protector's report. So I wanted to know whether that was the same company that assisted you. Mr. Oguma, you also said that Mr. Motsoeneng's salary is a sensitive subject. Well, be that as it may, the understanding we need to find out is now that he's in a more junior position, that is he still earning a higher salary than what he had as a COO? That's what we were asking. I also asked about the alleged bonus that he received, because we need to get clarity about that as well, and you didn't answer. I don't think we're going to get answers today, Chairperson, but I think it was important that we still put on record that these are questions that we asked that we never got answers to. Also, Prof, you and the acting CEO didn't answer when I said that I was quite upset when you said that political parties or general citizens shouldn't interfere in the running of the SABC. Be that as it may, that is also the reason why your viewership is dropping and why South Africans are saying we will no longer pay our TV licenses as a form of civil disobedience because you're not taking South Africans seriously. Lastly, Chairperson, one of the comments was that the reason why this board is fit and proper is because it's complying with legislation and therefore they are fit and proper. But the AG's recent report has given these guys a qualified audit because they are not complying with laws and legislation. So they've sealed their own fate. And I think I would then also agree with Honourable Self to say that let's move in terms of the Broadcasting Act, that we move a resolution for dissolving this board without any further delay.
Honourable members, Honourable Shibambo.
Thank you very much, Chair. It's apparent now with the submissions of the board members, Naidu and Kumalo, that there's a bigger problem than we had imagined with regards to the SABC board. It looks like there's a clique within the board that is running the board according to its own rules, because when the High Courts and the Supreme Court of Appeal says that you are wrong, they say, no, we're not wrong. We'll continue doing what we're going to do, we have been doing before. When the chief whip of the majority party speaks on behalf of his caucus, 243 members of parliament, that person, the chief whip, is isolated by Hlaudi and banished that no, he's the one who's wrong. When the minister in the presidency speaks on behalf of the executive, on behalf of cabinet, to express concern about the actions of the SABC, he's isolated as one person, that Jeff Khadewe is wrong. When the public protector speaks and then they're in the process of implementing the remedial action of the public protector, and then they realize that somewhere in the process of implementing that, part of the implementation might mean that Hlaudi must go, let's take it to review, the public protector is wrong. I'm sure even when we are unanimously speaking today as parliament here, they're going to say the same thing, that we're wrong, all of us. When we're saying that there is something fundamentally wrong with the SABC board, all of us are wrong here, except Hlaudi. So everything else is being sacrificed on the altar of protecting Hlaudi. Who is Hlaudi? I don't think we must be held at ransom for such a long time. And one myth that we must dismiss decisively is that he is the one who single-handedly introduced 90%, he must therefore be worshipped. That call has been there even before he was anything in the SABC. We were in the ANC, we called artists before, and they made the call long before he was the CEO, before he was anything significant. They made themselves that we want 90% or a certain representation in terms of content of broadcasting in the SABC. It's not his creation. So the hired crowd that is outside there that thinks that they're coming to protect 90%, it's not Hlaudi's policy, it has been there. The people in the industry themselves have been making the demand that there must be localization in terms of broadcasting in South Africa. And it's a logical thing to do that. Let us broadcast local content in a manner that will empower artists and those that perform in that particular space. So I think that the recommendation, actually the decisive action that should happen is that out of their own will, the board members as well, all of them must dissolve themselves now. We initially said that we must have an inquiry. It will take us a very long time. They must leave. They must actually first remove the illegal appointment of Hlaudi. leave as well, so that we constitute a board that is going to take forward the functions of the SABC, so that we have an entity that is properly managed, not by the whims and needs of individuals who think that they are much more important and more correct than anyone else. Please do not drag us through a long process, a wasteful process of taking everyone to court, review on the disciplinary hearing, review on the public protector. You'll possibly even review what we're doing here today. So please save us time and give an opportunity to a very important public institution, a public broadcaster that has to be saved so that it benefits all South Africans in a decisive way. So let us not really waste time. I think that amongst yourself, you must find it deeper in yourself that it's not about you, it's about South Africa. We have to protect the constitution, the rules that govern our country, and everything else that is necessary. The painful point which is raised by the board member there, that it must not be easy in all public institutions to destroy institutional memory. You can't, he says it's institutional genocide. It must not be easy just to arrive and you think that you are some superhero and then all of a sudden everyone else must go because you are there. It must not be easy, because there are certain things that you will make mistakes on, which if there were people who are experienced about the same thing would have advised otherwise. It's one of the things that has to be dealt with far much more differently. So perhaps the new board that comes into office must go and re-recruit some of the critical skills that have been lost because of the bullying tactics of Hlaudi and the people who are supporting him, so that we have a functional public broadcaster which is representative of all South Africans, which broadcasts local content and not individualize it as an achievement of one individual. It's an achievement of the industry itself. Like when the Creative Workers Union was formed, part of their founding resolutions was on proper local content. The manifestos, I think, of the ANC, of the EFF speak about local content in the public broadcasting far much more decisively. So it must never be ghettoized to be made a Hlaudi innovation. So the people who have been hired to support him must really be assured that there is no need to support Hlaudi to have 90%. We can have 90% and a properly run SABC. It doesn't mean that if you have 90%, you must have an SABC that is run like a spaza shop and where people can just change and shift positions as and when they wish. So I think that is must be very decisive in terms of how we provide guidance so that we do not have the recurrence of the same problems that we have been facing. Say the time of games has come to an end now. We must take serious decisions. Sure.
Thank you. Honorable Mbinda.
Thank you, Chair. Mine is a simple point. I wanted to point out to the acting GCEO and the gentleman that at the back there. I can't remember what your designation was there. Yeah. I wanted to point out that you have come here to mislead Parliament. You come here and you say to us that there was a disciplinary action, a disciplinary proceeding that was implemented against Mr. Hlaudi as part of your complying to the public protector's remedial actions. That is not correct, because here, this is what it says. In its remedial action, the report says the SABC board must ensure that there's a bulletproof before that, and the second one says appropriate disciplinary action is taken against the following. And then it mentions Mr. Motsoeneng, Ms. Lulama, and so on and so forth. Now it says disciplinary action must be taken against, not a disciplinary inquiry in which you are then going to investigate what the public protector has already investigated. And this is what the board means when it says that you have then taken over you've undermined the office of the public protector. And for that reason, I think it's clear that you are not fit. You talk about corporate governance as if you've been complying. You mention all of these things. But you then go and mislead Parliament on a fundamental issue like that. The public protector must not be undermined. This is a lesson that we learned in the Constitutional Court case against the Nganla case. And for that reason, I think this board is not fit. Thank you very much.
Yeah, thanks, Honorable Chair. I thought earlier on you indicated to the members that we need to interrogate the responses from the SABC board, and thereafter meet as a committee to decide on a way forward. For me, you know, you don't just get rid of people. There's a due process that must take place. We don't have to be in a hurry. And then if we want to get to the bottom of these issues, it is proper that at least we debate it. And then if there is a need for that commission or whatever to be established, then it must be established. Of course, even as I'm sitting here, you see, Chair, I am not happy, more especially with some of the responses. It is worse now when you hear that some of the board members were excluded in the process. But I understand within board meetings there are processes. I don't know whether if they were never told, obviously, it will not be easy for them to indicate whether they were for or against. Your memorandum, your article of memorandum is very clear. And what I thought they will zoom in, they will try and convince us in terms of these issues that we have raised, more especially the issue of the policy direction when it comes to recruitment and so forth, whether they have just followed those processes to the latter. For me, you know, it is not about the warm bodies. The issue for me is more about the policy direction. If they were able to slant the system or manipulate those processes, that's what I wanted, you know, us to know as board members. Rather than looking at the one bodies. You know, I don't believe in personal cults. That's how I was schooled. That's how I was brought up politically. But mine is more about the system, the policy direction. If they were manipulated, then I hear what the other board members are saying. And I'm also sitting here wondering why all of a sudden, why have they been quiet? Because I thought that there is a recourse, you know, even in board meetings. You can disagree, there is nothing wrong with that, but at least there's a process of looking at the majority view and so forth. But if they were never told, it's exactly where we want to know, it's exactly what we want to know, Chair. So I'm saying we must be given an opportunity as the committee, because as the committee we have got more facts, we have been interacting with most of the issues, and thereafter, then now, take whatever step that we think it is necessary for the public. Thanks.
Honorable Matisha.
No, thanks, Chair. I must say that I'm disappointed because that which I thought would permeate this discussions just before now has actually changed. I thought really we would be able to move forward and say properly how do we take things forward. But as a sequel to that which was raised by the other two members of the board, I then have an answer to the question that I raised when I started with my input there. Remember, I said, is the board fit to do its work? And the board members have now themselves answered that question, that they are not fit to do that which they are supposed to do. And I'm quite happy that in unison, the other members of the committee here are actually ossifying that which one raised. This board is not fit. But then the question is, what then has got to be truly done? I mean, I was quite, unhappy. I thought I was going to raise further questions. For example, the acting, what is acting, the gentleman, COO, it's up there now, okay? CEO. For instance, I mean, I was not happy when he refused, underline that please, to respond to some of the questions which we wanted to understand. I mean, we raised the issues around the finances, etc., and he said, no, I won't give you this. I can only give it to you next week. Now, that to me is a problem because this committee is the committee of Parliament that is there to basically deal with all this kind of things. And he had refused basically to do that. But then even beyond that, one had thought that more other issues that we had raised would be answered to, and we were going to make a follow-up now. But then I understand members of the board that the board is not a fit. In actual fact, they basically say, as people come together, individuals, to say that they're going into the board meetings, it's a few people. I further am happy that they indicate that the meetings do not only have to take place where we come together, we sit and speak together in a room, but then that you can send, the message around, and then people, members of the board, okay, will then be able to respond and say, yes, yeah, I agree, no, here, I don't agree, etc., etc. But then from what they are saying, the negative is actually the case. Therefore, this, the question that I raised is responded to. We don't have the board. It does not fit. We don't have the board. You are not there. As individuals go home.
Thank you very much,
Thank you.
Dr. Mulder.
Thank you, Chairperson. Mr. Motsoeneng will recall that about 6 months ago, I bumped into him one day on the 5th floor of the Marx building near my office. And I said to him, I'm not going to pay my TV license. And he was surprised and asked me why, and I said I can't find no reason why I should do that. I think today you understand what I meant on that day. Chairperson, I don't think we need to go into more questions and more details with all due respect. I think it's quite clear. We are all focusing on the board. It's as far as I'm concerned, it's a bit wrong because it's not the board, it's how the board functioned or how some members of the board functioned in what happened at the SABC. And if we replace the board, that's fine. That's part of the solution, but that's not the total solution. So it's fine if the committee moves a resolution to recommend the dissolution of the board. But the investigation into the whole SABC, I think, would also assist to once again make the SABC the gold standard of broadcasting, which it can be. Thank you.
Remember, you are making your concluding remarks, Honorable Van Dijk. No, you are fine. Honorable Van Dijk.
Chair, I'm covered and agree with most of the committee speakers, but I want to highlight that the lack of supporting documents presented by the board was quite disappointing. Taken in consideration the importance of this committee meeting, and which the board clearly did not take seriously. We didn't receive the disciplinary hearing outcome documents, any minutes of the board meetings on the issues. And if I recall, Mr. Aaron said that the board has an implementation plan in place to respond to the Public Protector's report. And while the secretary is here with her laptop, maybe she can provide us at least with that then. The other question that I do want clarity on is the SABC banned the broadcast of violent protest. This was found that this was in conflict with its duties as a public broadcaster and invalid in terms of the Constitution and Broadcasting Act. We want to know who took that decision and what logical base was the decision taken, on what logical base. And did anyone take responsibility for this decision? And then, Chair, the other thing that I want to mention from our side is that the board is actually now only 6 members, dysfunctional, and that the only thing to do is that the minister should appoint an interim board.
Thank you very much, Honorable Kalako. That's the last speaker.
No, Chair, thanks. I think, Chair, I'm covered. I will propose, Chair, that I think we don't have to go further now. I think as a committee, we'll have to, on our own, deliberate. Of course, members have already put forward proposals on what to do about the board. Because if it's 6 people minus 2 people, it's only 4 left now. You don't have a board. That's what faces us. So whether we like it or not, there's no way that we can keep things as they are at the moment. Because once we do that, we're going to fall into the same trap which this board have been in, where the executives takes control and determines everything. So it's going to be very much important for us, Chair, that we now ask the officials, the board, to leave us, and then as a committee, conclude on the way forward. Chair, thank you, Chair.
Yeah, thank you very much. Members, I think we have come to the conclusion or the end of the session with the board. We have listened to them, we have asked questions, they responded the way they did. Members are not satisfied. And then the committee must remain and take a decision on what to do. On what to do, taking the process forward. You are released, members of the board. And then, wait a minute. You are released, there is tea for 10 minutes. And then after that, the committee convenes. We proceed and take decisions on the basis of the information we have. Thanks. 10 minutes gone. All right.
It's not there. It's
Yeah. Members, can we take seats or can we take positions? Can we take our positions? One thing that must be clear, we have released the board in terms of engaging with them. But they are not being chucked out of the house. I think that must be clear. If they leave the committee room, it's out of their own volition. We haven't chased them away. Because we are not chasing away anybody from the committee meeting. That thing must be very, very clear. Because the committee meeting is a public meeting. Once it's a committee, it's a public. So members of the board, and I said that to the minister, members of the board of SABC were not being chased away from the house, but they were released as members of the board in terms of the discussion. Members, we have reached the stage now where we need to reflect on the way forward. After listening to this board, and over and above that, after listening to the two members of the board, Mr. Naidu and Mr. Mavuso, not Mr. Kumalo, Honorable Shivambu. I think that was the last straw in terms of, or a heavy contribution in terms of how we need to take a decision. I'm going to allow the ANC, let me not say the ANC. I'm going to allow Mr. Kalako, Honorable Kalako, to speak so that we hear the views.
Chair, I think, as all of us, I think there is an agreement and a consensus around the issues which are bedeviling the SABC and the dysfunctionality also of the board. So I won't repeat those things. Members have already gone through them. I will propose that officially we make it a resolution of the committee to dissolve the board. And immediately we institute expeditiously an inquiry on the SABC as a whole, so that we can get into the bottom of the problems there, and we sort them once and for all. And of course, I'm proposing this mindful of the fact that with those who help us on the legalities will advise us on the due process, on the steps that must be taken, on the rules, on the sections of the Act that allows us to actually to institute an inquiry into the SABC and also dissolve the board. Thank you, Chair.
Thank you very much, Honorable Self.
Yes, thank you, Chairperson. I think we all agreed that the current board is dysfunctional and that it must carry some of the responsibility for the situation at the SABC. As you would be aware, dissolution of the board is governed by Section 15A of the Broadcasting Act. And the requisite provision is in 1B of that section. And it says the National Assembly may, after due inquiry and by the adoption of a resolution, recommend the dissolution of the board if it fails in any or all of the following. 1, discharging its fiduciary duty. 2, adhering to the charter. And 3, carrying out its duties as contemplated in Section 1311. I think I could say that probably all of those 3 grounds are applicable in this particular case. But the difficulty is what is the chicken or the egg come first? In other words, can one dissolve the board before a due inquiry, or does one need a due inquiry before one passes a resolution to dissolve the board? And as somebody who has a lot of experience in litigating against the SABC, I can tell you that they will probably litigate against it if we get the procedure wrong. So my very strong advice is to get some decent legal advice about what would constitute a due inquiry. And I'd also respectfully suggest that the due inquiry is into the board, not into the SABC, because that's the reading that I have of that particular section. Because I fear that if we got involved in a due inquiry into the SABC, we would be here until Christmas and beyond, because of the complexities of what goes on there. That those problems need to be solved, I have not the slightest doubt. But I think that it's probably not what was intended in 15B. The other issue that worries me slightly is that while the board is dissolved, the executive committee continues to sit. And I think we would be failing in our duties if we addressed only the board and not the deficiencies of the executive committee, on which many of the people sit who directly or indirectly were responsible for the mess that the SABC is in. And so I think if we're getting some legal advice, we might also want to look at what happens to the executive committee in the absence of a board. Thank you, Chairperson.
Thank you. Thanks very much. Any other member? Ms. Honorable Mbinda and Honorable Shibambo.
Yeah. Honorable Chair, obviously I'm not comfortable for the dissolution of the board if we are still going to conduct further investigation. But what I thought we will probably do, if we feel that at least they have not acted in due diligence or in terms of whatever fiduciary duties of the board, it is always better that sometimes you rather suspend the board. But when it comes to the issue of the executives, those are employees and they are governed by the basic conditions of employment and the Labor Relations Act. And then in that one, I would rather say it depends whether there are serious allegations against a particular employee. That is when now you start dealing with that. But whether that is within the competence of this committee or not, I doubt very much when it comes to that. So we are not saying something is not right, but at the same time, for me, I think that it's better that we follow a proper process, because people these days have got rights, even if those rights have got limitations. Thanks.
Thank you very much, Honorable Shibambo.
Thank you very much, Chair. So the section in the Act, the Broadcasting Act, that deals with the dissolution of the board, like verbatim reads as follows: that the National Assembly may, after due inquiry and by adoption of a resolution, recommend the dissolution of the board if it fails in any or all of the following. There are three things. Number one is discharging its fiduciary duties, adhering to the charter, and three is carrying out its duties as contemplated in section 1311. So I think we agree, all of us, that the board has failed to deal with those three aspects which are grounds for removal, for dissolution of the board. I think that we should take a resolution, because that section says that after due inquiry, we'll have to do an inquiry. And I think actually part of what we started today was an inquiry, because we got to question about some of the decisions that they took. We spoke about fiduciary obligations that they have. And then when the National Assembly sits on the 25th of October, we then recommend a resolution by the House that the board should officially be dissolved, and then we then deal with the interim board as is required by the Act, and then we then take it from there. We'll have to, unfortunately, bear some of the pain that has been caused with wrong appointments and all those other things. But we're sure that the interim board can then be able to attend to some of those issues, and then we'll take it from there.
Thank you. Honorable van der Merwe.
Thank you very much, Chairperson. I think I've been covered by Honourable Shivambu, but I do think that there's general consensus that we move for a resolution to dissolve this board. But I think also legal opinion will be the safest course of action, just to make sure that we actually are compliant with this section of the legislation. But also just to say that there is precedent in terms of the Ngubani board, which was also dissolved after due inquiry, which formed the same sort of setup as we had here. We also, as a previous portfolio committee, when members resigned, the board collapsed. So there is already an example that could say that this setup that we've got here today will constitute due inquiry. But just to make sure in terms of the Act that we are compliant, so that we don't have comebacks. Thank you, Chairperson.
Honorable Chair, I think we're together. But I had thought the proposal that was made earlier on by Honorable Kalako was as well based on the fact that there are two members who have just tendered their resignations as of now, which then suggests that there is a bit of a challenge with regard to a quorum as of now. And I had thought, in the light of what we've been doing still this morning, at least we have a picture, coupled with the resignations that have just been tendered today. We can then move in the direction which says, yes, indeed, let's dissolve, but the inquiry was then to go deeper into the issues in the SABC, so that we are then able to make thorough investigations around a whole range of other issues. But in the main, I think that proposal was based on the fact that two members have just tendered their resignations as of now. So there is a bit of a legal technicality if they were to convene a meeting next week and say it's a board meeting. Thanks.
As you contribute, Honorable Kungubel, just to check with members, we have, in Parliament, we have legal services. Maybe we need to engage them they are supposed to advise the committee, because they are legal advisors or legal services of Parliament. Maybe as we speak, we need to think about that.
I think the thrust of the issue is agreed upon. all what is required is how best to do this. And that how best is very critical. Otherwise, we can be found in the same situation with them that we are doing what we are just criticizing them for doing. As we consider that, I'm just throwing now from lack of knowledge on my side. Remember, after this resignation, there is no board in practical sense, practically. Two, there's oversight that must be done. There's oversight that must be done on behalf of, supposedly, the board is supposed to always be there. So if now it doesn't exist, whatever you will do, whether you will do it in November, who is doing the work of the board currently waiting? Because I guess we've got a responsibility to protect SABC. There's a lot that we've been exposed to, which is worrisome. If something were to happen based on the influence of these people, we having not had an interim measure, I don't know what kind of interim measure is supposed to be there. So all that I'm saying is that the trust on the way forward is agreed. Maybe what we need to discuss, how urgent we come together after a legal what to call, after getting a legal advice, and take a decision on the basis of that. I want to say, Chair, to me, it's not undermining our parliamentary legal services. I think we also need a senior counsel what to call legal advice. There should be somebody who of a particular stature, because the decision we're going to take is of deep national interest. So I thought I wanted to make those.
Comrade Flight.
No, thanks, Chair. Actually, you know, in the composition of the board, the Act says that 9 members of the board, which must include the chairperson and deputy chairperson, will constitute the quorum at any meeting of the board. It actually says 9 members. It does not say 50% of members or 50% plus 1. So there must be 9 warm bodies. And we do not have that now with the SABC, meaning that there is no more a board of SABC that can constitutionally and legally take decisions. Now, the Act does not provide for what should happen when a board has dissolved itself. The Act does not provide for what are the interim measures. I think what we need to do, actually there's no need for an inquiry. Maybe I must withdraw my earlier proposal because there's no need for an inquiry because the board is non-existent in any way. Let's request the Speaker to convene the National Assembly sitting earlier than the 25th of October in terms of the current program of Parliament, and then would then constitute an interim board as is required by the law. An interim board of 5 that is going to run the affairs until we've interviewed the number that is required for the 12, and then they will then be completed by the remaining ones. The problem is that if we do not do anything now, we're leaving a vacuum. The people who are remaining as appointed board members, they cannot sit to take any decision because they're not legally permissible to do so.
Can you repeat that?
The ones who are remaining now cannot sit and take decisions because they're not legally permissible to take decisions on anything that relates to the SABC because it requires a minimum of 9 members to take decisions. So the proposal is that let us as a committee request the Speaker to convene an extraordinary sitting of the National Assembly to then take a decision on filling the vacant, like the interim, on putting the interim board, because that is what the Act provides for, that you can put an interim board in place. And then we'll then engage in the process afterward. Actually, the Parliament has been convened before when there were urgent decisions that had to be taken. I remember when we had to be suspended by Parliament as the EFF. A special sitting was convened for that purpose. So now this is a serious issue about saving a public broadcaster that must be attended to as a matter of urgency, that we have to appoint an interim board, and then they will be given a mandate. in terms, and it will be easier because once I've got an interim board, let us say next week, Tuesday or Thursday, then we can then give that mandate, a new mandate to the interim board that part of the things that they have to do is to comply with the PP report, deal with some of the transitional issues, we appoint a permanent board that will stabilize management of SABC. And then we have a functional public broadcaster which has got management, not one individual.
Honorable Kekana.
Yeah, thank you, Chair. In fact, mine was to say that Honorable Ngugubele is right that it's very important for us to get a senior counsel or a retired judge to make sure that we closed everything and so that we take the speaker process. Then we get the interim board and it's where then we can start to deal with other matters. I thank you, Chair.
Honorable Tolashe.
I might not understand all the details on how we go through this process, but I would caution the committee not to jump the gun. Let's follow the processes. We are a committee within an institution. Let's allow the leader of the institution, that is the Speaker's office, to take us by hand moving forward. Because I'm afraid we'll put some requests that are not going to be adhered to for right reasons sometimes. If there will be a need of retired judge and so on, then let the Speaker's office advise so. But I would be more comfortable, Chair, if consistently we mention of the fact that then the SABC board need to be investigated. That one should not be dropped, because if we do that, we'll be taking the whole responsibility of the mess that they've put the whole country into. So let's not jump the gun, let's be patient, let the legal people take us by hand so that we follow this. That there's no board, it's a fact. So there's no investigation whether there's a board or not, there's no board now. So let's just follow the processes. If there's a need for the parliament to be convened, let that be, because we also should not allow a vacuum, because I can imagine we are not dealing with dumb people here. There will be some creativity. If there will be a gap, there will be some creativity, and we must begin to really interact and make sure that there is no such a thing, because the public is looking forward for this committee to resolve this matter once and for all, Chair. But also the issues of pace. I think we need to move with the necessary speed in this matter, Chair. Thank you very much.
Honorable van der Merwe.
Chairperson, no, I just want to say I fully agree with what the sentiments the members are raising, but we must just go back to, remember this board emanated from a board that collapsed. In fact, 2 boards were collapsed between 2012 and 2014 due to members resigning or the board being actually dissolved as well. So we've got examples of what the previous portfolio committee did, and Honourable Shivambu is quite right. The next urgent step is to appoint an interim board. So we need to simply be advised in terms of, and in fact, Tembi was there when we did those processes. So this is what we'll be embarking on. It's not a process that this parliament has not done before. There are 2 examples of how we conducted ourselves previously, where 2 boards collapsed and we had to appoint an interim board, and some of those members who were then in the interim board were actually appointed to the new permanent board, which we've now also dissolved. And I think Tembi would also be able to give us advice. But just to say that there is an example of how we conducted ourselves previously, but Honourable Shawambu is quite right to say the next very urgent step is to actually appoint an interim board.
Tatemkwen.
Yeah, thank you, Chair. No, I wanted to reiterate that point of precedence in the sense that we don't have a board, and I think that's the message that needs to reverberate throughout this entire chamber. Is that we don't have a board, and based on the precedence of the 2 cases of the dissolutions that we've had before, I think the correct step would be to appoint an interim board and be very prudent in appointing a new board. But this must happen as soon as possible. The SABC is dying. Thank you very much.
I think I hear members saying that this board is dysfunctional, and therefore we must appoint an interim board. as soon as possible. I think this is what the committee say. And in doing that, we must follow due processes so that we are not outside the law. I think this is what the committee is saying. Where I don't hear the committee properly is the inquiry. Yes, sir.
Again, maybe in the legal advice it will be clarified. I have no doubt in my mind, Chair. There's a lot that needs to be dug into this board, which would not come out in this short space of of time. So whatever appropriate process that would help us to cut open what is in there will assist, because the problem, if we don't do that, even when you interview the new board, you will not know the kind of strength you're looking for. Having not exposed yourself to the depth that inform the weaknesses of this protocol of this board. So an investigation into this board, let me say this. I'm not joking when I say I'm worried about the cleanliness of the relationship between this board and the COO. I don't know what's happening there. So that's why it's important that whatever appropriate title is given, some investigation needs to be done. I don't know what you call it.
Dr. Mulder.
Chairperson, I'm sorry to take you back. I just want to ask a question. I was not part of the previous processes. If, for example, now 2 members of a board have resigned, like happened today, so in terms of the interpretation of the Act, the board cannot function and cannot take legal decisions. But does that make automatically that the board no longer exists? In other words, isn't it possible for some other people to come and say, but I've been appointed legally as a member of the board. I'm still a member of the board. Because somebody else resigned, you cannot just accept that I no longer exist as a member of the board. So I'm not sure if it's not necessary to dissolve the current board before you can appoint an interim board.
Honorable Shibam and then Kalako.
No, Chair, the interesting thing about this legislation is that most legislation that speaks about quorum speak about percentage of members. But this one doesn't say percentage. It says 9 members must be present for a quorum of a board. So it's 9 warm bodies. So we do not have that. So there can never be a board that can take legally permissible decisions in the current form. I think that is the same challenge that we confronted in the previous boards, and then an interim board was put in place. The good thing about an interim board is that we do not follow the long interview processes and applications that otherwise would have to happen when we appoint a permanent board. We'll agree ourselves as a committee that these are the 5 individuals who are going to be the interim board of SABC, and then we recommend to the National Assembly for appointment, and then we commence a process of appointing a permanent board. That will include an advertisement, nominations, interview processes, and then a final resolution by the National Assembly on who are the permanent board members. Those are some of the things that we have to deal with in the interim. Now, the last issue I want to deal with is that Parliament is allowed through law to institute a parliamentary commission of inquiry. So we can still do that even in the process of the interim board. And the Parliament, by the way, can subpoena any member of society to give evidence on one issue or another. So we can then say to the previous board members, can we be given explanation on what exactly happened, so that we give guidance to the permanent board that will be appointed after the interim one. So in the process of the interim board being in charge, because decision has to be made, we can then have that parliamentary inquiry, and then we then give concrete recommendations to the permanent board that is going to be appointed after a process has been engaged upon. Thank you.
I'll give Dr. Mulder, but before that, because we have people who are dealing with these matters in the legislature here, Parliament, it will be necessary to have one of them, because they are in the House, advise us on how parliamentary processes are followed. But you can come, Dr. Melda.
Thank you, Chairperson.
And
I
then
underst-
after that, we'll,
Yes.
we'll ask them to give us advice.
I understand what Honourable Shivambu is saying, that you need 9 bodies to take legitimate decisions, and we don't have 9 bodies. That's correct, I understand that. But if I would argue as a member of the current board, I would argue and say, but I've been legally appointed as a member of the board. I've not resigned. You cannot just go and appoint an interim board while I'm still a member of the board. I would argue and say, why don't you appoint 2 new members instead of those that resigned, so that we have, again, 9 members? Why would it be wrong to take, as part of the process, to say we take a decision to dissolve the board and then appoint an interim board?
I think that's the way to go. Can I test that? That's the way, dissolve and then put a new, an interim board.
This is tricky. Can we dissolve without an inquiry? Just as a clarity on that. I agree we should dissolve. We agree.
Wait, members. I'm going to give the legal services to advise us.
I'm coming to that.
But before that, I will give the Comrade Stella, because she was like Honorable Van der Merwe. They were part of the committee that dissolved the previous boards. Not even 1, 2. Over to you, Comrade Stella.
Thank you, Chair. I think as Floyd, Honorable Shivambu has outlined, that the Act stipulates that the committee must take a recommendation or a resolution that must be adopted by the National Assembly, the resolution to dissolve. Then the National Assembly must adopt. Once the National Assembly adopts, what you can do is to put a proposal also on the same day through a motion to say we then vote or adopt again the interim on the same day. But a resolution has to be taken by the House. It moves from here. An inquiry is what we just said, that's why Honorable will also recall, that's what you did. We did the same thing. Like they were here, we asked questions because we've had reports and all that, and after that we submitted a report to a recommendation to the Speaker, and it was tabled in the House and members adopted, and we moved for the interim board. That must not last more than 6 months, the interim board. Thank you, Chair.
Yeah. Makadebono banjalo. Comrade Montle.
My understanding, we have agreed, Chair, that we clear what we want. Can we finally ensure that we, having heard all what we've said, the legal opinion finally says to us, I think we agreed on that. Because the problem is that we'll end up doing the work of that legal process in this meeting.
We recommend to the Speaker, then Parliament, for the dissolution of the board, this board of 4 people, and then move for the interim board. And how do we get the interim board? After the resolution, we go back and get those people. Give us everything, members.
No, Chairperson, what will happen is when we decide on interim board, each political party will come with names that we want to propose to serve on the interim board. So the ANC, the IFB, EFF, COPE, whoever will come with some ideas of people we think will be most suitable to serve on that interim board. And we will then go in a discussion and we will shortlist names and then agree on 5 names, which we then give to the House. So it's not an interview process. If you, for example, think that there's an eminent South African that's got good skills in terms of broadcasting or legislation or whatever would be relevant for the interim board, you would come with those names, those proposals, and we will actually negotiate amongst ourselves. And that is how it's done, not through an interview process.
Honorable Matisha?
You see, I agree with that which all members are saying. But then I got a bit confused by yourself, Chair. I mean, if we simply say we are going to recommend, it then says they are going on, they are working until such time we so do. That to me is a problem. I think we need to come up with a resolution that they have, that has stopped altogether. They are not going on. And then the recommendation, yes, will come when we, as Honorable Shivambo is saying. But then right now, they can go on and work unless you put it otherwise. And of course, the legal persons can say that. But then even further than that, Honorable Shivambo spoke about the 24th, I think, which to me, I must say, it's a longer period because you are talking about workers there, you are talking about lots and lots of work that is there, etc. And a lot really must be done. And you are talking about the persons here whom we have said are not actually doing their work as excos, etc. We don't trust. Now, what are we then saying? Please advise. Yes, recommend, but then I had thought that with immediate effect, Bamsanda, Radwanage, with immediate effect, that will have to cease.
Can I allow legal services? Are you legal services? Both of you. And after that, I'll hand over to legal services.
Very briefly, Honorable Chair. My understanding is that whatever we're doing here cannot be implemented until such time that the National Assembly has taken a resolution. That's my take. Especially on the dissolution part. Am I right? Yeah. So I'll appeal to this forum not to cut corners and allow this process to unfold in such a way that we don't create problems in the process of us addressing a problem. Already, Honorable Shivambo was talking about an extraordinary meeting. He even suggested sometime next week. And I don't think we must seriously fight to have this thing attended to as a matter of today. Let's allow the due process to unfold until such time that the National Assembly has taken a resolution sometime next week, as suggested here. So as to between now and the time the National Assembly will take a resolution, whatever will happen, I think we can afford to see whatever. I don't think we have 3 weeks or so. We're talking about something that will then happen within a week or so. So I'm saying we must not cut corners and create problems in the process.
Okay.
By saying we want this thing, we are afraid they will complicate things between now and the day the National Assembly will take a resolution. We must not do that.
All right. Honorable Mbenda.
Thanks, Honorable Chair. I thought initially we have agreed that we will solicit a legal advice. And secondly, I am also concerned about the shortcuts because that is why I was recommending, because I thought that it is within our competence in this committee, at least to immediately suspend the board of directors, pending. It's always pending investigations. That's how it has always been. And but it seems as if the majority of us are thinking that what we were doing here, this process that we were involved in, was an inquiry. To me, it was not an inquiry. In fact, this process, it has assisted us to take a decision whether to investigate further or not. In terms of even your natural rules of natural justice, you know, those board members, we need to understand one thing, that they do have rights. I think you have already alluded, you say, Honorable Mulder. You can't just, I know that we are in a hurry. We want to make sure that at least we do away with them as soon as we can. But for me, it is always proper that we follow a due process, because there are other legal implications. I'm not a lawyer, but with my experience and understanding, if we were to be challenged, that is why, Honorable Chair, I'm suggesting that we can suspend, obviously, and inform the minister that immediately they are suspended. And then in the interim, we follow the process that has already been allowed by the Deputy Minister and also Honorable Shivambo in terms of informing the National Assemblies and so forth, so that they don't continue doing the work, because we are skeptical here that they may immediately we leave here, go back and whatever. We will just suspend, and then there is no need for us to be really in a hurry. If we are saying a week, next week, or a week after, or whatever, even if it is on the 25th, a decision will be taken by the National Assembly, then for me, it is not a train smash. Yeah, thank you.
Yeah, no, I think that's speaking from experience as a former CEO of a company and a board member. Members, I will hand over to our legal services, but I subscribe to this notion of do a thorough job, not being in a hurry. Yes, be in a hurry, but slowly, so that you perfect what you do. Today we had a meeting with the board, so we had everything. And that is why we have been saying, we can't do all these things that you say we must do. Institute an inquiry and all of that before listening to the board. I think this is what we have done today. As the committee was satisfied, hence we can take a decision. Can I hand over to you, sir, so that you just advise us on how to proceed properly without any challenges? Thank you. This is one of the legal services people for Parliament.
Thank you, Chairperson. Good afternoon to yourself and to the honorable members, including the visitors and the guests. My name is Ntutuzelo Vanara. I am the Senior Parliamentary Legal Advisor, employed by Parliament to the best of my abilities, assist committees of Parliament, as well as Parliament as an institution, to take decisions that are consistent with the law. That is what I'll attempt to do in the next few minutes. If I were to sum up the questions that I am to assist the committee, there are 4 questions. The first one, is there a board in existence subsequent to the resignation of the 2 non-executive board members? The second one is the process to dissolve a board of the South African Broadcasting Corporation. And the third one deals with the interim board. What happens if that board is not in existence? And the fourth one is whether what unfolded today, or the exercise the committee embarked upon today, could constitute an inquiry in terms of section 15 capital A, subsection 2 of the Broadcasting Act. I must say that I was the dedicated advisor to the Portfolio Committee on Communications at the time the committee was charged with a similar, not exactly the same, but a similar exercise, when the committee looked into the allegations against the board of against the chairperson, the then chairperson of the board, and I assisted the committee with the process that unfolded until the committee had prepared a report to the House. And that process had challenges, but as lawyers, we always learn from these legal challenges, and they prepare us to become better persons for tomorrow. And I hope I'm going to share with you the experiences that we have gathered in that exercise. In simple terms, in response to the first question, is there a board? Yes, there is a board. However, the board cannot quorate because it does not have sufficient numbers to do so. I'm going to get to the second question around the process to dissolve a board. We are reminded constantly by the Constitution and the apex court in the country to always conduct ourselves within the framework of the Constitution and the laws. That is referred to as the rule of law. Now, for anything that a public functionary or an institution that exercises public power is to do, it must be guided by the law. We might want to do things the way we think they are correct, but if the law does not allow us to do things we think are correct, we are going to find ourselves having acted contrary to the law and in breach of the principle of legality, which is incidental to the principle of the rule of law. The guidance then is found in terms of the process to dissolve a board is found in the Broadcasting Act, which governs the SABC. And this relevant section there is section 15 capital A, subsection 1, paragraph B. And I want to quote that section verbatim. It says, the National Assembly may, after due inquiry and by the adoption of a resolution. After due inquiry and by the adoption of a resolution, recommend the dissolution of the board if it fails in any or all of the following. Roman figure 1, discharging its fiduciary duties. Roman figure 2, adhering to the charter. And Roman figure 3, carrying out its duties as contemplated in section 13, subsection 11. So what is the process? The process is that there must be, firstly, due inquiry. That there must firstly be due inquiry. And out of the outcome of the inquiry emanates a recommendation. Which ties then to the question, the fourth question, asked what unfolded today in the committee, does that qualify as due inquiry? The answer to that must be a no. It must be a no because what the committee was doing today was to solicit. There has been a number of things happening. And the committee, at the SABC, and the committee wanted to know Why are these things happening? How are they happening? Who is responsible for those? I think that was the exercise that unfolded today, which then should have enabled the committee to be in a position to decide whether or not this board is worth continuing existence. Now, in terms of the process, once the board has come to that decision, sorry, not the board, the committee. The committee has to now, and I've listened to honorable members, and I'm not going to summarize because that is the job of the chairperson of the committee. You will come to a decision. And if that decision then is, you are going to institute the inquiry in terms of section 15 capital A 1B, then that is the decision of the committee. But what it means is there is a lengthy process of a due inquiry that must unfold. And what then follows is, assuming that at the end of that inquiry you come to a recommendation that this board must go, that is then what you would recommend to the House. Then the question is, what happens in the meantime in respect of the interim board? Again, we get guidance. We get guidance from section 15 capital A, subsection, let's start with subsection 2. If your recommendation to the House to dissolve the board successfully persuades the House, subsection 2 then says the House would have to communicate that to the President. And what the President must do is in subsection 2, the appointing body, which is the President, in paragraph C, has no discretion but to dissolve the board if you receive that the resolution that recommends for the dissolution of the board. So that cleans up the process of removal, of dissolving the board. Then you don't have a board, what happens? Subsection 3 then says, upon the dissolution of the board contemplated in subsection 2C, a process I've just outlined, the appointing body, who is the President, must appoint an interim board consisting of persons referred to in section 12B and 5 other persons recommended by the National Assembly. Now, the persons referred to in 12B, just want to quickly get to 12B, is the Group Chief Executive Officer, the Chief Operations Officer, and the Chief Financial Officer. So those are the 3 people the President would on his own get. The other 5 would then have to be recommended by the Assembly. So that takes care, in my view, of this particular process. Of course, a due inquiry requires, and I had Honorable Bindas talking to the rules of natural justice, and that is a lengthy process of affording people. Firstly, the committee will then have to formulate charges against the board, give the board an opportunity to respond to those charges. Of course, they're entitled to legal representation. That is as a matter of right. I am not going to bore you about that detail for now. But I do want to make the point that perhaps, and in view of the fact that this process might take a lengthy time. The board cannot function currently. And for it to function, it will have to be resuscitated by the assembly, because it is the assembly that must now start a process to get new board members to join the remaining ones. What could be done to circumvent the lengthy process that could legitimately be done, my view would be, if the assembly holding a view that it's holding about this current board with all its challenges, to express a view that because of the challenges that are there, you are not going to come to its assistance in terms of nominating people to join the queue there. And therefore you ask the remaining board members to resign and step down. Then once they've stepped down, then there will be no board. And you can then start a process to get an interim board with a view to appointing a permanent board. Thank you, Chair.
I'm very worried about the last one, asking the remaining board to resign, because they won't. There you are, members. There is the advice, Linda, and Honorable Shivamo.
Yeah, I just wanted to check the issue of suspension, whether this committee cannot suspend with immediate effect, pending whatever investigations. Just what I wanted to check, because that's what I thought at least is the approach that we will take, if it is permissible.
No, thank you, Chair. The remaining members of the board cannot obviously sit as a board that can take permissible decisions legally, because they do not constitute a quorum, which is required by the Broadcasting Act to be 9. And to suspend them or remove them individually, we need an inquiry process, which might take long. And to dissolve them, we need an inquiry process. But the duration of that inquiry process for the dissolution purposes will be determined by what areas do we want to focus on as a committee. And then we ultimately then recommend to the National Assembly plenary to dissolve the board. I think that let's agree in principle that if for us to put an interim board in place, we need a dissolved board, and that must be dissolved through an inquiry. Let us inquire them. Then let us go back to that. If that is what it's required as per his legal advice. If the legal advice is giving is that we necessarily have to put an inquiry, let us put an inquiry, and we'll determine the length of that inquiry, and then we will then report to the National Assembly, and then we'll then take the process of the interim board. But I don't think that we must rule out, Chair, the request that we can make to the board members who are remaining. We can say as the committee that in terms of the act that has established you, you cannot sit as the remaining members. We advise as a committee that you should resign so that we can constitute a legal entity, which is an interim board, which must run the SABC. I don't think we must rule out. It's a political process. You must remember that we are not lawyers here. We are politicians. We must take a political decision collectively to say we're going to advise the remaining members of the board to step aside. If they don't, then we'll continue the process of inquiry. If they do, it makes our work easier of putting an interim board in place and then advertising for the permanent board that must be put in place to run the SABC. I think that the sentiment has been expressed to them, all of them, when we engaged earlier, that we are not pleased with the progress that they've made thus far. This neglect of fiduciary obligations, this neglect of the board charter, of basic management and board principles that they had to adhere to, and all those things there. I think they've understood that. So let us write to them. If they don't, we'll then take an inquiry, and then we'll recommend to the National Assembly that this is what should happen. And it's not prejudicial, because it might possibly reach a conclusion that maybe with new information that they give us, we might take a posture that says that we're going to appoint the remaining members of the board, not the entire 12 that is required by the Act, so that they do not take us to court that in any way wanted to remove them from the beginning. We can have an inquiry that is open-ended, and then if they justify themselves successfully, then we can then appoint the remainder of the board members and recommend a term to them in terms of what is required by the law. Then we'll take it from there.
Yes, they don't cooperate now, so they can't take decisions. They are as good as they are not there. Is that the understanding? Because they can't take decisions now because they are 4. Yes, sir.
Honorable Chair, the first part of my input will be in the form of a question, and then the last one will just be a proposal, perhaps just for us to try and see if we can conclude this matter. Can the appointing authority suspend the board? If because you said something that I missed a little bit. Can the appointing authority as of now say to the board, you are suspended? The last one, Chair, from what you say, the route of an inquiry is unavoidable. I think that's what he say. So I had thought we'll move in the direction which says, let's agree on the route of an inquiry, and the rest will follow. But if we can address the question that I asked positively, so it will then address some of the issues that have been raised. So it will then suggest that in the process of an inquiry, the appointing authority, if it's allowed, will then, in the process, suspend the board or dissolve or whatever. But I'm saying the principal position that we want to take now is that of an inquiry, and the rest will follow. That's what I thought, because I don't see us concluding a whole range of other nitty-gritties here. Otherwise, we'll continue to debate this issue until tomorrow. But I thought we want to take a principled position on the inquiry and allow your office to go and do further investigations, so long as you are within the framework that we have agreed upon. But the question that I asked earlier, I think is also pertinent. Thanks.
Thank you, Chair. Yeah, thank you, Chair. I will humbly second. In fact, it was raised long time ago, the issue of inquiry, and request the committee that let us accept that that will be a good way to deal with this thing once and for all. I thank you, Chair.
Yes, thank you, Chairperson. Just in terms of the earlier question that was asked, I don't see any provision in the Act for suspension of board members. And I think that was deliberately so as to allow them to act independently. But I do agree that what we need to do is possibly the following. First of all, to resolve to establish an inquiry into the fitness of the board to perform its duties. And secondly, to mandate that inquiry to report to the National Assembly as soon as possible, and possibly even by say the 24th of October. Because what I don't agree with the legal advisor is that it's necessary to formulate charges. Because this is not a disciplinary inquiry. This is an inquiry into fitness for office. And I think there's enough evidence that we have, both out of the Public Protector's report and out of the state of governance in the SABC at the moment, to sustain a charge that prima facie the board is incapable of fulfilling its duties. If we pass a resolution to that effect, you can then write to the board members and you say, this is what's going to happen. This is what we've resolved. You may wish to consider this, and you may wish to resign. And that might just be the way to handle it, in a way that the board members are then faced with the choice of going through an inquiry which might be quite damaging to people's reputations, and simply resigning.
Thank you, Chair. I would propose then, having listened to that advice, although I said in my previous experience maybe it's what they learned, I would propose that probably the committee recommends dissolution, or that the board be dissolved, and at the same time institute the inquiry. Because that's not going to happen at the same time. You can say, because institution of the inquiry is a process towards dissolution of the board. Therefore, you are not going to recommend today, you're writing to the Speaker to say, when the next House sits, let it consider this, and therefore the National Assembly agrees to what they're agreeing on, and indeed they give the instruction based on what they agree on. Thank you, Chair.
No, Chairperson, I think the proposal as articulated by the Honourable Self is the best way to go. We obviously, in terms of the legal advice, must have a due inquiry. I also don't think it should be as laborious as he has suggested with charges. I think we've had a lot of evidence here today to suggest that the board is no longer fit and proper to lead this organisation. And I think once you write to them and say to them that we are going to institute an inquiry into their fitness to hold office, you might find that they would automatically resign anyway, because it will be so damaging to their credibility and their careers going forward, which then actually would make our job much easier. Then we might not have to have the inquiry after all. So I think the proposal of Honourable Self is a sound proposal, and I would like to support that you write to them saying we are going to institute an inquiry, see whether they'd be willing to resign, as Honourable Shivambu had suggested, making our job much easier, and then we can proceed with the other proposals.
Yes, Comrade Floyd.
Thanks, Chair. You know, the grounds for removal of a board, of dissolution of a board, is failure to discharge fiduciary obligations. It's failure to comply with the board charter. That is not a disciplinary hearing. So the legal advice cannot be correct to say that they must come with legal representatives and all those things there. It's a governance issue that we can deal with, that you have not complied with your fiduciary duties, and that is our decision in terms of if they want to review, like all decisions of Parliament, they can review it outside this process. So an inquiry can be far much shorter than a disciplinary process. I think that the inquiry route will be able to help us in terms of, but the issue that we will have to possibly deal with in the inquiry, Chair, is that it's possible that the acting COO, the one who has been appointed now, could have been illegally appointed by a non-corrading board. So there might be actually a lot of rearrangements, including executive of current affairs, Hlaudi, could have been appointed through a non-corrading board, which necessarily requires nine members of the board. And the two who came here, they say that they are shocked that there's a new COO in SABC who was executive head corporate affairs before. That is what the board members, Mavuso and I do said, that they are hearing for the first time, meaning that there was no 9 members of the board when that decision was taken. So we're dealing with a situation where you have got COO Tugwane and executive Hlaudi who are illegally appointed by a board and recommended to a minister for, I don't know where she gets the instruction or the mandate to sign such an illegal decision. So we're dealing with those issues. Let's have an inquiry. I don't think it will take us a very long time. We can set one day aside. We can agree that there's going to be an inquiry of the board maybe next week, Tuesday or Wednesday, and then you'll interact with the speaker and then the chief whips in terms of a possibility of tabling an urgent report to the National Assembly, because there's a vacuum that has been created and a crisis that has been created in the SABC now. We can then agree whether we stick to the current parliamentary program, which says that the National Assembly will sit on the 25th of October, or there must be a special sitting that must be convened in terms of the rules of the National Assembly that permits for that to happen.
Honorable Madisha.
No, thanks. I thought we were actually done with the whole thing. And in my own opinion, we're going back. You see, yes, the issue of the inquiry, etc., may take 3 years or even more. I say this because of the kind of things that those people have done. And some of those things, of course, have been reported by them in this very meeting, where some of the members rose and said, yeah, I don't agree, there, I don't agree, etc., etc. Therefore, if we talk of an inquiry, I don't believe really it is going to take only 1 day. That is the first thing. Now, secondly, we agree that we don't have the board. The board is not there, okay? Now, what do we do as this committee? The board is not there. Now, the third thing that I want to put is that these are people who are not employed. Yes, there are those 3 who are employed who sit on the board, and these other people, you can say, in line with the Labor Relations Act, etc., come and so on. You can't do that. So one of the members here raised this point, and I agree with her that request these other people to give South Africa the space, let them shift so that our country can be able to move forward. I agree again with the 4th point that was raised, that we should have an agent, parliamentary sitting, request the Honorable Speaker to ensure that we do indeed have that. Fifthly, that we request, actually that is exactly what you or we as a committee need to do, to say to the minister, make sure that things run properly here until such time we shall have said as Parliament to handle all these kind of things. But then I want to insist, Chair, that you go on, by you, I'm not referring you as an individual, or we go on and say, hey, there is going to be a problem if we go on with the, this inquiry, etc., etc. That is not going to be a problem. We've got to make sure that as a matter of agency, everything goes on, but then at the moment, we've got to ensure that by hook or crook, this whole thing ends immediately. We don't have the board. Let us move from there.
Members, I think we have said our say. And I'm convinced that members do agree with the inquiry in principle. But we can't institute an inquiry without touching base with the speaker. Is that the understanding? Because we must allow the speaker, or we must conduct the speaker in relation to that. Secondly, we request or we write to, I think that was Comrade Floyd earlier and seconded by Comrade Self, that we write to the board and say, because of ABC, you haven't performed, if I can put it that way. We quote whatever is in the act and all of that and say, will you please resign? I think the members were saying that. Will you please resign? And if, because they are not there, I mean, they don't correct, and if they don't do that, we proceed with the inquiry. If they do, they make things easy for us to put in place an interim board. Am I not confusing your issues, members? Doctor?
Chairperson, may I just say something? I agree, you are right. I'm just not clear about one legal thing, but that's with regard to section 15A, where you mentioned the 3 hurdles that needs to be in terms of you want to dissolve the board. One, not doing the fiduciary duties, and then there's a second one in terms of the charter, etc. But if I remember the wording correctly, it said if they fail in any or all. Now the question would be, do they have to fail in all 3 or only in any one of those 3? But that's a legal thing, we can look at that. I was just thinking in terms of the the letter that needs to be written at this stage, Chairperson. Wouldn't it be better to send a separate letter to each and every individual trustee that are still a member of the board themselves? In other words, there's not going to be a meeting of the board can't function, it can't meet. We are appealing to the individual members of the board left, that we ask you to resign in terms of unanimous decision taken by the committee in Parliament.
Can you do that, members? I think there is no problem with that. Honorable Van Dijk, we are closing the meeting now.
Yes, I just want to find out if there will be a time frame to this letter, and in the time, in how long will they have time to respond to the letter?
Honorable Van der Merwe?
Yeah, Chairperson, I'm not going to answer that question. I just wanted to bring to your attention as well, as we are sitting here as a committee, Mr. Hlaudi Motsoeneng outside has been saying that for those who are thinking we are gone, they are wrong. This is just the beginning. So I just also want to say to you that Mr. Motsoeneng remains defiant. But not only that, I want to also ask you a question which might be a difficult question, Chairperson, but once we look at the inquiry into the fitness of the board, whether we will also be looking at the actions of the Minister of Communications in her role in aiding and abetting the board in their actions. Because it's our responsibility to hold the executive to account. And I just wanted to put that on record, that I think that will also be important, because throughout this entire process, where this broadcaster has stumbled from one crisis to another. We've not heard the voice of this minister. And I just thought it would also be prudent of us to include that possibly in the inquiry. But I'm just playing devil's advocate.
I think the terms of reference of the inquiry will not be worked out here. Definitely a technical team will have to do that, informed, of course, about what we're saying. Honorable Machop.
Thank you, Chair. I'm just applying my mind to the matter that raised by my colleague, Chivambo, about the appointment of the COO. He says it was illegal because there were few. Now we are saying, while you were here in front of us, giving us the report, now is illegal because there are few. I'm just trying to reverse our decision, Chairperson, because I'm worried when he said the appointment of the COO was illegal because there were few board of directors. Can you give more explanation about that?
Now, on the basis of what was said by the two members, Naidu and Mavuso, that they were not part of the preparations of this meeting. And therefore the board that presented here and took decisions, including that of the CFO, acting CFO, did incorrect and therefore illegal. I think that's the simple point that the comrade was making. So there is no board because it doesn't correct. They are individuals. Comrades, I want us to conclude because I think we are clear of the inquiry and then the processes that will have to be followed by Parliament. Comrade Floyd?
No, Chairperson, I was saying we should not be worried about Hlaudi's rentings and some chicken bravery. We're not going to be intimidated by Hlaudi. There were people who were saying here in Parliament that they're not going to pay back the money, but they went all the way to Venda to look for money to pay. And he thinks that is above the law. He's not going to be CEO or any position in the SABC by the end of this year. So he must stop that chicken bravery which he talks about every day, that Yena is indispensable. There's no one who is indispensable in South Africa. We've got the rule of law. We've got a constitution that guides how things must be done. So he must not treat us like we're kids and people that he talks to there in the SABC and everything else every day and harasses without consequences. The time of games has come to an end. He must live with that reality now.
Members, I think we are okay now. I think we are okay. Can you switch? We are okay. I think we, in principle, have taken a decision for the inquiry. Processes must be followed. Parliamentary processes will have to be followed properly. Secondly, we'll have to write to individuals of the board, those remaining, to say this is the state of affairs in the board. May you please resign. And then we hear what they say. But the decision is that we'll go for an inquiry. Is there anything else, members? On the summary, because I really don't want us to spoil the summary, because that's what you agreed upon. Of the process. That's something will form part of the parliamentary process. Any move for adjournment or closure?
No, got you wrong, Chief.
Tolashe?
No, Honorable Chair, I thought I must just raise this for us as the committee to please request you to talk to the minister as the most important stakeholder, just to make sure that what then is alleged to be happening, it doesn't. Because not only are we doing our constitutional work, but it also dents individuals' images, and it's not really creates a good environment for the committee to do its work. Just that of us respecting the responsibilities that are assigned to us by the Constitution of the Republic. Her, as a minister, talk to her people, just to caution them to say that things that should not be.
Members, thank you very much for your... sit down, please. Let me say before you leave. Thank you very much for your contributions. I think everybody did have his chance to say whatever one wanted to say. And I think really we must talk to the minister, because we can't talk to Motsoeneng. The minister is a shareholder, so that he doesn't do what he's doing. And I think after this, we'll have to talk to as the committee, we'll have to talk to the public on the decisions that we have taken, because people are waiting for this committee meeting as to what it will pronounce. But thanks for your contributions and advice. We'll see you when we meet again. Thanks very much.